Okay, I'd like to welcome everybody to the May 13th meeting of the Water Quality Control Commission. The first agenda item is roll call. So Ms. Jones, would you call the roll?
I will. Good morning. I'm going to call Commissioner Barunda. Are you here in the room?
I am present. Yes.
Are you? Oh, you're online. Well, good. Welcome.
Yes. Well, thank you.
Commissioner Brankard.
Present.
I will call Commissioner Candelaria, although I know he has said he was not going to be here. Commissioner Fry.
Present.
Commissioner Harms. Commissioner Laney.
Present.
Commissioner Langer.
Present.
Commissioner McWilliams, who I know is also not here. Okay. Commissioner Moander.
Present.
Commissioner Patton, also excused absence. Chair Thompson.
Here.
Commissioner Bayless.
Here.
Commissioner Vigil.
Here.
Vice Chair Zemlik.
Here.
Let me ask one more time. Is Commissioner Harms anywhere? Very good. Chair Thompson, you have a quorum.
Thank you. And I would like to welcome everybody. This is a very interesting meeting, challenging. Again, my name is Bruce Thompson. I'm chair of the commission. We've got a very full agenda. And the second agenda item is approval of the agenda. So I would like to make one modification, if the commission allows, is I'd like to move agenda item number 7, discussion and adoption of the 2025 Open Meetings Act. I'd like to move that up to agenda item number 5, right after public comment. I think it makes the meeting flow better and everybody understands the open meetings constraints that we will operate under. So with that modification, I'd entertain a motion to adopt the agenda.
I have a question, actually. So number 5 is the public hearing, and perhaps this is more of a question for the hearing officer. What I had read in the announcement was that it should come after the meeting. Does it matter procedurally if it's part of the regular meeting?
I don't believe it does, because we'll make a couple of different smaller records related to hearings within the longer meeting.
Okay, then I move to accept the agenda with the modification.
Second. Okay. Since we have one person attending via the web platform, I think we should do a roll call vote on this.
Okay, to approve the amended agenda. Commissioner Barunda, how do you vote?
Yes.
Thank you. Commissioner Brankard?
Yes.
Commissioner Fry?
Yes.
Commissioner Laney?
Yes.
Commissioner Langer?
Yes.
Commissioner Moander?
Yes.
Chair Thompson?
Yes.
Commissioner Bayless?
Yes.
Commissioner Vigil?
Yes.
Vice Chair Zemlik?
Yes.
The motion passes.
Okay. Agenda item number 3 is approval of the minutes. They were sent out a couple days ago, I believe. Any comments, suggestions regarding the minutes? Hearing none, I'd entertain a motion to approve the minutes.
So motion.
I'll second.
Commissioner.
I'm sorry, Mr. Chairman. I just noticed in the minutes that there was references to vote by Commissioner Velasquez, but I believe Commissioner Velasquez was replaced by Commissioner Bayless. So that should be deleted. And I believe in the votes, on the deliberation, it says Commissioner McWilliams absent, but I believe she abstained. She was present but abstained in the votes during the deliberation on 2384.
I don't have those in front of me, but I believe on the first day it shows that she was present, and on the second day she was absent, which she was.
She left early. Okay, it's been moved and seconded. There was one correction. We ready to vote? Ms. Jones, could you call roll?
Yes, to approve the amended minutes. Commissioner Barunda, how do you vote?
Yes.
Commissioner Brankard,
Yes.
Commissioner Fry,
Yes.
Commissioner Laney,
Yes.
Commissioner Langer,
Yes.
Commissioner Moender.
Yes, but I do want to make a quick record. I wasn't present, but I did invest the time and energy in reviewing the minutes and the documents for that hearing. So I approve.
Thank you. Vice Chair Zemlik, Chair Thompson,
Yes.
Commissioner Bayless,
Yes.
Commissioner Vehil.
Yes.
Motion passes.
Okay, thank you. Now, agenda item number 4 is public comment, and this is for Commissioner Brankard.
I'm sorry, Mr. Chair. There were 2 sets of minutes. Did we approve both of them? There was an April 8th and an April 9th. Is that the intent of that motion?
Who made the motion? Commissioner Barunda, did you make the motion to approve the minutes?
Yes, I did.
And was that for both days or just one day?
My understanding was that was one day.
Okay. Semlik?
Can I suggest that we modify the motion to include either, okay, to accept the minutes for the meeting of April 9th? Sorry, yes, April 9th, which is the second day. I guess I should probably clarify that the commissioner was moving to approve the minutes of April 8th.
Agenda item is April 8th.
Yes.
Oh, okay.
So we've already voted, so I think
Okay, can we?
we have approved the minutes of April 8th. So we need a second motion to approve the minutes of April 9th.
So I will move to approve the meeting minutes from the meeting on April 9th, 2025.
Second.
Is there discussion? You're ready to vote? Ms. Jones?
Commissioner Barunda, how do you vote on the minutes for April 9th?
Yes.
Thank you. Commissioner Brankard,
Yes.
Commissioner Fry,
Yes.
Commissioner Laney,
Yes.
Commissioner Langer,
Yes.
Commissioner Moender.
Yes, subject to the statement I made on the last vote as well.
Thank you. Chair Thompson,
Yes.
Commissioner Bayless,
Yes.
Commissioner Vehil,
Yes.
Vice Chair Zemlik.
Yes.
Motion passes.
Okay, thank you. Okay, again, any further discussion of minutes? So agenda item number 4 is refers to public comment. And this agenda item is for people wishing to make general comments before the commission. It's not for specific comments related to any of the agenda items that are on the agenda, specifically the public hearing on amended stream standards, City of Raton temporary standards, and the wastewater reuse rule. So this is for general comments only. And is there anybody that would like to make general comments before the Water Quality Control Commission at this time? Okay, thank you. I would like to make a comment. Over the last 2 weeks, perhaps, I have received a very large number of emails addressed to me as chair of the commission, in reference to the wastewater reuse. And I very much appreciate, I've tried to respond to all of them. The emphasis on every one of these is that we have to protect the state's surface and groundwater resources, protect the quality. And I don't think there is anybody more dedicated to that cause, to that initiative, to protecting our water resources than the members of this commission. We're all spending a lot of time on this. And so I appreciate that. And I am willing to take any written comments, and I will try and respond to every one of them. Yes, ma'am, I'll take one question. We've had we've had 11 days of public hearings, and in each day of that public hearing, we had two opportunities, one around noon and another one at the end of the day. And so we had very lengthy and numerous public comments on this, and the record is now closed. And so that's why we're not taking comments. Yes. Please, would you come to the
Does
is that a dais?
like to quote one of our great scientists, Dr. Jane Goodall, in my public comment. Each day we make an impact and a decision about the world around us. And each day we get to choose the impact that we're going to make. So I just ask you to think of that. And that's my public comment.
Thank you.
Thank you.
Thank you. There is a Mr. Weatherby on the platform that wants to make a public comment. And again, if this is a general public comment, we'll accept it. If it's not, if it's specific to one of the items on our agenda, we won't take it.
Chair Thompson,
Yes, ma'am.
question for you. I'm trying to remember for this particular public comment, are we taking names of the people commenting?
Yes, we should have. I'm sorry.
Thank you. I'm a member of the general public. My name is Jane Doe.
So again, Mr. Weatherby, do you are you requesting to make a general comment, or is this about one of the agenda items? Mr. Weatherby. Okay. Since we're not getting a response, we're going to move on. I neglected at the very beginning of the meeting, we've got two new commissioners, and I would like to give them an opportunity to introduce themselves. So let's go first with Mr. Barunda. Would you just take a minute or two and tell us who you are, who you work for, what's your expertise, and how you expect to work with the commission?
Yes, sir. Yeah, hi, everybody. My name is Ron Barunda, or Ronald Barunda legally. I've actually been in water and wastewater for going on 22 years now. Started at the city of Alamogordo. That's where I was born and raised. But in 2019, I jumped over to the city of Las Cruces, where I became the deputy director of water, basically oversee the water system and the aquifers and whatnot here in the city of Las Cruces. I have a degree in engineering. Let's see what else. Yeah, just glad to be here. And you know, earlier the lady said about, you know, protecting our waters and our resources, and that's really what I'd like to bring forth to this commission is just understanding that, you know, I've been in this field a long time, and that's always been my my focus was, providing the best water to our residents, to our customers, and to our citizens. So that's going to be my primary focus, is make sure that we do that.
Thank you, and welcome to the commission. I'm
Thank
glad
you.
we've got a little more representation from the southern part of the state. So,
Yes, thank you. I do apologize. I was trying to get up there this meeting to Santa Fe, but unfortunately that didn't work out. But I should be there next meeting in person.
okay, great. And we do have another commissioner from Las Cruces, and that's Katie Laney with the Department of Ag. And you might want to talk about sharing transportation with her. Did you, Commissioner
Mr.
Blanchard?
Chair, just to clarify, I believe Mr. Brunden is appointed by the governor as the municipal representative. Is that correct?
I believe so, yes.
Thank you.
Thank you. The other new commissioner we have is Chelsea Langer with the Department of the Health, Public Health.
Thank you. Yeah, so I'm Chelsea Langer. I'm with the Department of Health in the Environmental Health and Epidemiology Bureau. I'm now Bureau Chief as of yesterday. My background's in environmental and occupational epidemiology, and the Bureau really covers the health impacts of pretty much anything in the environment, including water. So thank you.
You ready to move? Move on to the next. The next agenda item is discussion and adoption of the 2025 Open Meetings Act resolution. As a public board or commission, we are subject to the State Open Meetings Act, and every year we adopt a resolution to demonstrate our compliance. So I'm going to turn it over to our counsel, Eduardo Ugarte. Button.
Well, the resolution was circulated and open for questions if anybody on the commission has any questions. It's essentially the same resolution as last year, just I think one minor edit.
Questions or comments? I would entertain a motion to approve the 2025 Open Meetings Act resolution.
So moved.
Second.
Okay, it's been moved and seconded. Is there any further discussion? You ready to vote? Ms. Jones?
To approve the Open Meeting Act resolution, Commissioner Barunda, how do you vote?
Yes.
Commissioner Brankard,
Yes.
Commissioner Fry,
Yes.
Commissioner Laney,
Yes.
Commissioner Langer,
Yes.
Commissioner Moander,
Yes.
Chair Thompson,
Yes.
Commissioner Bayless,
Yes.
Commissioner Behill,
Yes.
Vice Chair Zemlik.
Yes.
Motion passes.
Public comment that may have gotten Mr. Weatherby.
Yeah, Mr. Weatherby, are you able to talk to us yet?
He needs to unmute him.
Yes, you're muted. It doesn't look like it's working. We'll move on then. Agenda item number 6 is a public hearing in the matter of WQCC 24-65R, which is a proposal to amend the stream standards 20.6.4.126 and 20.6.4.141, which are standards for segments of stream up on the Los Alamos property. And this will be a public hearing. And I believe Ms. Worth is the public hearing officer. So I'll turn it over to you.
Thank you, Mr. Chair. Mr. Baca, this is when we would begin the transcript.
Yes, ma'am, I'm on. Thank you.
Thank you. My name is Felicia Orth, the hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC number 24-65R, petition to amend 20.6.4.126 NMAC, and 20.6.4.141 of the New Mexico Administrative Code to establish a segment-specific temperature criterion for a portion of the Upper Sandia Canyon Assessment Unit. Petition was filed by Triad National Security and the U.S. Department of Energy's National Nuclear Security Administration. We received two technical notices of intent, one from the Surface Water Bureau of the New Mexico Environment Department, and of course the other from the petitioners themselves. There are a total of 3 witnesses. I would like to ask for appearances of counsel, but let me do 2 things first. One, the hearing is being recorded and transcribed in addition to this WebEx recording by Paul Baca, certified court reporter. The hearing is also being interpreted between English and Spanish and English by Ms. O'Grady and her team of interpreters. I see Ms. Zeman and Ms. Cardenia online. Ms. Zeman and Ms. Cardenia, do you and each of you swear or affirm that you will translate faithfully between English and Spanish and English? Please unmute yourself. Okay, there you are. Thank you so much. Ms. Zeman? Okay, I may hear from her later.
Betty, if you can hear us, can you please go on the English channel?
Okay, if you reach her, you can have her confirm in a little bit.
May I give instructions on how to use the interpretation function?
I was just about to ask you that. Thank you.
Thank you. Good morning, everyone. This is Lisa O'Grady with Logar Interpreting and Translating Services. As the hearing officer mentioned, we are providing Spanish and English interpretation. In order to access the interpretation, if you're online, at the lower left-hand corner of your screen, you'll see a globe. You will need to click on the globe and then choose English. Everyone will need to choose English. And with the exception of those who want to listen to the Spanish interpretation, when you click on the globe, you'll choose Spanish. Buenos días a todos. Estamos proporcionando interpretación al inglés y español. Si quieren escuchar el español, por favor, miren en la esquina inferior de su pantalla y allí puede hacer clic en el mundo y luego escoger español. If there's anyone present in the hearing room that would like to listen to the Spanish interpretation, we can provide you with headsets. If you can just raise your hand, I will bring a set of headsets over to you. Buenos días. Si hay alguien aquí presente en la sala de audiencias que quisiera escuchar al español, por favor, levanten la mano y con mucho gusto le traigo los auriculares.
Thank you, Ms. O'Grady. So let's have appearances first. Ms. Scott is representing the department, and I believe she's on the platform. Ms. Scott? Oh, there you are.
Brecken Scott for the New Mexico Environment Department.
Thank you. And Ms. Dolan or Ms. McReynolds?
So good morning. I'm Maureen Dillon for Triad National Security co-petitioners in this matter. And on the platform with me is Maxine McReynolds. Thank you.
Thank you. So while you're there, Ms. Dolan, if you would please, knowing that we have 3 witnesses, we'll hear from all 3 of them. We already have the full narrative of their testimony in the record. I'm sure the commissioners have already read that. I will also invite public comment obviously, when we have completed the technical case. But assuming that this hearing is to go smoothly and the commission were to deliberate immediately following the close of the record, what would your time estimate be?
For speaking for Triad, we have a brief opening statement, perhaps 10 minutes and half an hour for each witness. And if, with your permission, we'd like to present our witnesses as a panel together for questions.
All right, thank you for that. And Ms. Scott, do you have an estimate for the department's presentation?
So my opening is roughly 5 minutes. And we also, so one of the 3 witnesses is an NMAC witness, and that should be less than the total 30 minutes that's allotted. So.
All right, thank you very much. I think for those of you interested in hearing the resumption of the deliberations in the produced water matter, that's the most information we have at this point, if you would like to go to other activities in the meantime. So, yes.
Excuse me, if I may, Madam Hearing Officer, we also have co-petitioner counsel, Stephen Yoakum as well,
Right.
for DOE and NSA.
Mr. Yoakum.
Hello, Stephen Yoakum, representing the Department of Energy and NSA Los Alamos field office.
Thank you very much. All right, so pursuant to a request made in email earlier, although petitioners would ordinarily make their opening statement first, they've agreed that Ms. Scott will make a brief opening first, and then we'll hear from Ms. Dolan. Ms. Scott.
Your Honor, this is Mr. Maxwell. I entered an appearance as well.
Oh, that's right. I'm sorry I forgot you, Mr. Maxwell. I don't usually forget you. Mr. Maxwell, I'm glad you're on the platform.
Good morning. My name is Nicholas Ray Maxwell. I'm one of the people of Lee County, New Mexico, a member of the public, and I'm here to listen and participate today. Thank you.
Thank you very much. All right, now Ms. Scott.
Good morning, Madam Hearing Officer, Chair Thompson, and members of the Commission. Thank you for being here today. My name is Brecken Scott, and I represent the Surface Water Quality Bureau within the Water Protection Division of the New Mexico Environment Department. NMAC is not the petitioner in this rulemaking, but the department is here today in support of the petitioner's proposed amendments to the New Mexico Administrative Code, which are specifically to 20.6.4, .126, and .141 NMAC. My goal in this opening statement is to briefly provide some regulatory context and help situate you in this proceeding docketed as WQCC 24-65. The petitioners will address the substance of their proposed rule amendment. The Water Quality Control Commission, known as the WQCC, is directed and required to adopt water quality standards for surface waters of the state under the New Mexico Water Quality Act. The Water Quality Act states the standards shall at a minimum protect the public health or welfare, enhance the quality of water, and serve the purposes of the Act. Furthermore, the Act states that in making standards, the Commission shall give weight it deems appropriate to all facts and circumstances, including the use and value of the water for water supplies, propagation of fish and wildlife, recreational purposes, and agricultural, industrial, and other purposes. Water quality standards include site-specific water quality criteria. The New Mexico Administrative Code states the Commission may adopt site-specific numeric criteria applicable to all or part of a surface water of the state based on relevant site-specific conditions, including the concentration resulting from natural background exceeds numeric criteria for aquatic life, wildlife habitat, or other uses. The NMAC further state that site-specific criteria must fully protect the designated use to which they apply. Designated use means a use specified in each classified or unclassified water quality segment for a surface water of the state, whether or not it is being attained. The basis of petitioner's proposed rule amendment today is to amend language in an existing water quality segment and to classify and create a new water quality segment with a differing designated use than the existing segment. The NMAC states, the removal or amendment of a designated use to a designated use with less stringent criteria can only be done through a use attainability analysis. Use attainability analysis means a scientific study conducted for the purpose of assessing the factors affecting the attainment of a use. Requirements for use attainability analyses are set out under 20.6.4.15 NMAC, including requirements under federal regulations at 40 CFR Part 131. The WQCC may adopt site-specific numeric criteria in accordance with 20.6.4.10F NMAC, and any person may petition the WQCC for adoption of such site-specific criteria, subject to certain requirements under the NMAC. The Commission may also adopt site-specific criteria based on natural background. As stated previously, petitioners propose to amend rule language in one section of the NMAC and to add a new section of the NMAC to classify and create a new water quality segment. The State Records Center and Archives, known as the SRCA, treats this type of rulemaking and rule filing as an amendment, as opposed to a new rule. In addition to the Water Quality Act and associated rules, any person who initiates a rulemaking shall follow the New Mexico State Rules Act and associated regulations regarding public participation. Between petitioners and NMED, we ensured all public input, public notice, and public comment requirements were met, which brings us to today's public hearing as the final step in the rulemaking process. NMED's technical witness testimony will provide more detail on much of the above. NMED respectfully requests that the WQCC deliberate immediately following the close of the technical case. NMED further requests that a hearing officer report not be requested by the Commission in this matter. The parties anticipate circulating a final order and statement of reasons and concise explanatory statement in the next few weeks should the WQCC adopt the rule amendment. Thank you for your time and consideration in WQCC 2460.
Thank you, Ms. Scott. Ms. Dolan?
Thank you. Actually, Mr. Yoakum is going to make a very brief statement before we do.
Thank you.
Good morning, Chair. Good morning, Chair Thompson, Commissioners. My name is Stephen Yoakum. I'm here representing the National Nuclear Security Administration, Los Alamos Field Office in this matter. Maureen Dolan of Triad National Security will make the principal presentation for the petitioners. For that, I'd like to provide some background on the petitioners. NNSA is a semi-autonomous agency within the Department of Energy, or DOE, that is responsible for enhancing national security through the military application of nuclear science. Triad National Security, or Triad, is a Delaware limited liability corporation authorized to do business in New Mexico. Triad is comprised of three nonprofit entities: Bell Memorial Institute, University of California, and Texas A&M University System. Triad manages and operates the Los Alamos National Laboratory, or LANL, on behalf of the NNSA Los Alamos Field Office. It consists of over 900 individual facilities and 13 nuclear facilities situated on the Pajarito Plateau. It employs over 16,000 employees. It shares boundaries with the Pueblo de San Ildefonso, Sandoval, and Santa Fe counties, National Park Service, and U.S. Forest Service lands. Triad and NNSA Los Alamos Field Office are co-permittees on the National Pollutant Discharge Elimination System Permit number NM0028355, issued by EPA, for discharges to surface water through 11 outfalls at the LANL site. This permit includes requirements contained in 20.6.4 NMAC. It is our intent to amend two subsections of this part to establish a segment-specific temperature criterion for a particular assessment unit located solely on the LANL site. As co-petitioner, the NNSA Los Alamos Field Office.
Mr. Yoakum, you're reading a little faster than the interpreters can, but we're trying to capture every word for interpretation in the transcript.
Would you like me to?
No, just slow down.
As co-petitioner, the NNSA Los Alamos Field Office fully supports the presentation by Triad to that end, and will now yield the floor to Ms. Marie Dolan.
Thank you, Ms. Dolan.
Madam Hearing Officer, Chair Thompson, and Commissioners. Good morning. I am Maureen Dolan, as Mr. Yoakum said, counsel for co-petitioners Triad National Security, LLC, the management and operating contractor of Los Alamos National Laboratory. As you've heard already from Ms. Scott, the Commission granted this hearing today in response to petitioner's third-party request to amend 20.6.4.126 and .141 NMAC to establish segment-specific temperature criteria for the westernmost portion of the Upper Sandia Canyon Assessment Unit. This assessment unit is a perennial stream segment within the Rio Grande Basin, fully located within landfill boundaries and designated for cold water aquatic life use. The AU is listed as impaired for temperature. Petitioner's use attainability analysis, or UAA, has shown that this impairment is likely due to ambient conditions in the canyon, with air temperature as the primary driver of canyon water temperatures. Petitioners propose to divide the Upper Sandia Canyon Assessment Unit into two segments, with the downstream portion retaining the current cold water designated use and temperature criteria, and adding a new segment with a cool water aquatic life use and an added chronic or 63 temperature criterion of 25 degrees Celsius. As we intend to show today, our proposed amendment to New Mexico's water quality standards would more accurately reflect the existing uses in Upper Sandia Canyon, would have discrete applicability within the stream segments on landfill property, and would protect water quality locally and downstream. As Ms. Scott described in her opening statement, the New Mexico Water Quality Act and New Mexico's accompanying administrative regulations provide for both the Water Quality Control Commission's authority to establish surface water quality criteria and for third parties to petition the Commission to amend established criteria. The Upper Sandia Canyon AU is perennial, but it is also effluent dependent. The source of most of the flow is the lab's NPDES outfall 001. Outfall 001 discharges cooling water from the laboratory's power plant, treated sanitary wastewater effluent, recycled sanitary effluent, and treated cooling tower blowdown. If not for this industrial wastewater discharge, the Upper Sandia Canyon AU would be ephemeral. In 2005, WQCC designated Upper Sandia Canyon for cold water aquatic life use with a segment-specific temperature criterion of 24 degrees Celsius. The WQCC later eliminated the segment-specific criterion and replaced it with a general criteria for cold water aquatic life use set out in 20.6.4900 H2 NMAC, and thus in addition to the maximum temperature criterion, or Tmax, of 24 degrees Celsius, this change added a chronic criterion of 25 degrees Celsius. NMET's integrated report, required under Federal Clean Water Act sections 303D and 305B, has listed the Upper Sandia Canyon AU as impaired for temperature since 2018. The IR assigns the segment a category 5/5B. Impairment in this category suggests a use attainability analysis may be necessary to determine whether the designated use is in fact appropriate. Appendix A of the IR states, quote, AUs are listed in this category when it is possible that water quality standards are not being met because one or more current designated use is inappropriate. After review of the water quality standard is conducted, a use attainability analysis, UAA, may be developed and submitted to US EPA for consideration. 20.6.4.15A1 NMAC states that the Commission may remove a designated use that is not an existing use if a use attainability analysis demonstrates that attaining the use is not feasible because of a factor listed in 40 CFR 131.10G. UAAs are described in both federal and state water quality regulations as structured scientific assessments of factors, including physical, chemical, biological, and economic factors affecting attainment of use. And for UAAs conducted by third parties, New Mexico regulations require development of a work plan approved by NMAD. Here, NMAD approved a work plan for petitioner's UAA in spring of 2020 and identified factor 131.10G1 as the basis for the UAA inquiry, which was to determine if, quote, natural thermal conditions are preventing the attainment of cold water aquatic life use in the perennial reach of the Sandia Canyon Assessment Unit. The approved work plan is attached to our petition as Exhibit A. The approved work plan set out both substantive requirements, including specific lines of evidence and areas of analysis, and procedural requirements for stakeholder outreach, public engagement, and consultation with state and federal regulatory entities. In accordance with the work plan, the final UAA report, Petitioner's Exhibit B, examined air and water temperature data, flow data, and modeling results over time and at locations throughout the segment. It analyzed the presence of threatened or endangered species and critical habitat, considered aquatic life surveys, and included data pertaining to additional designated use criteria for dissolved oxygen and pH. As documented in the final report and as petitioner's technical witnesses will testify, cold water aquatic life temperature criteria are not attainable throughout the entire segment, described in 20.6.126 NMAC. And the UAA further demonstrated that air temperature is the primary driver of water temperatures and that natural conditions in the canyon likely prevent attainment of the cold water ALU criteria. The final UAA therefore recommended dividing the current AU into two segments. As the report shows, this proposal reflects the highest attainable use. It would not negatively impact downstream segments and would continue to be protective of aquatic life. The land use attainability analysis has been in progress for many years, and petitioners have worked throughout with NMED and regional stakeholders. Petitioners completed a draft UAA report, released it for public comment, and incorporated responses to the public comments in their revised UAA. We presented at a number of stakeholder meetings and had a second public comment period last year, from May 13th to June 12th, 2024, and we received no comments during that period. Because the final UAA shows that a cold water ALU is not attainable throughout the entire segment, petitioners propose amending these portions of the New Mexico Water Quality Act to divide Upper Sandia Canyon into two segments. As we've heard from Ms. Scott, and we will hear from NMED's witness, the Environment Department Surface Water Quality Bureau supports petitioners' proposed changes. I'd like to thank the Commission for your time and NMED for your time in the matter, and move on now to present our witnesses. Thank you.
Thank you, Ms. Dolan. Let me just check to see whether Mr. Maxwell had anything to say by way of an opening.
I do not have an opening. Thank you.
Thank you. So under the Commission's rulemaking rules, all witnesses are giving their testimony under oath and subject to questioning by the other parties and, of course, the commissioners. Let me also put on the transcript that in addition to the 2468 10 commissioners who had identified themselves earlier as being present. I noted that Commissioner Harms joined us as we were beginning the opening statements. Let's see. Ms. Dolan, if you would introduce your first witness.
Sure, I'd like to call Timothy Goering, please.
All right, Mr. Goering, would you please spell your first and last name for the transcript?
Yes, my first name is Timothy, Timothy, and the last name is Goering, Goering.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Ms. Dolan.
Thank you. I intended, Madam Hearing Officer and Commissioner and Chair Thompson to make a couple of preliminary requests with respect to entry of exhibits into the record. First, we'd like to confirm that our exhibits A through N, which were attached with the petition, are part of the record.
They are certainly part of the pleading log and part of the record insofar as they were attached to the notice of intent. Let me just pause for a moment in the event there are any objections to full admission of the exhibits. Part of the hearing record. No. Hearing none, they're all admitted.
Thank you. And then second, we'd like to request that as we present our witnesses, relevance of the supporting exhibits should be clear and we can enter them at that time. I'd like to actually enter them together, but I hope that will give anyone an opportunity at that time to make specific objections. So hopefully that will be adequate. We'll just go forward. Mr. Goering, who is your current employer?
My current employer is Triad National Security.
And how long have you been employed by Triad?
I've worked at Los Alamos National Laboratory under different management contracts since 2007.
Thank you. Mr. Goering, what is your current role, Triad?
I'm an environmental professional working in the environmental professional and compliance group on their water quality team.
And would you please describe your duties?
I've been supporting the Surface Water Quality Standards program. I'm also involved on a number of groundwater and surface water related issues in our group.
Thank you. And please describe your educational qualifications.
I have a Bachelor of Arts in Environmental Science from the University of Virginia and a Master of Science in Hydrology and Water Resources from University of Arizona.
Mr. Goering, do you have before you what has been identified as Petitioner's Exhibit O?
I do.
And do you recognize Petitioner's Exhibit O as your curriculum vitae?
Yes, it is.
Is this document true and accurate to the best of your knowledge and belief?
Yes, it is.
Petitioners would like to move for entry of Exhibit O.
All right. Any objections? It's admitted.
Thank you. Mr. Goering, do you have before you what has been described as Petitioner's Exhibit V?
Yes, I do.
Do you recognize Petitioner's Exhibit V as your pre-filed direct technical testimony?
Yes, that's what it is.
Was this testimony prepared by you or under your direct supervision?
Yes.
Do you have any corrections to your testimony?
No, I have no corrections.
Is your testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
If you were asked today the same questions, would you give the same answers?
Yes.
Madam Hearing Officer, petitioners offer Petitioner's Exhibit V.
Objections? It's admitted.
At this time, I'd like to allow Mr. Goering to provide the summary presentation of his technical testimony that he has prepared and request that Ms. Jones grant Mr. Goering permission to share his screen. Thank you.
He's good. And Mr. Goering, people tend to speed up when they read. So if you would just keep it nice and slow.
Thank you, I will. Good morning, Madam Hearing Officer, Chair Thompson, and Commissioners. My name is Tim Gehring, and I'm here to present my technical testimony in support of the petition to establish a segment-specific temperature criterion for the portion of Upper Sandia Canyon Assessment Unit, which we will refer to as AU. This is a summary of my testimony. I'll briefly go over my qualifications. I will then talk about the physical setting of Sandia Canyon, where the assessment unit is located, and then we'll discuss the regulatory framework for this use attainability analysis and the history and the need for conducting the UAA in Sandia Canyon. I will also review the work plan and the requirements of the work plan and discuss our extensive process engaging with the regulator, primarily New Mexico Environment Department, and our stakeholder outreach and public engagement process. And finally, I will summarize the recommended amendments to 20.6.4126 and 20.6.4141. Whoops. So, as I mentioned, my education, I have a BA and MS in hydrology and also environmental science. I have nearly 40 years of experience in hydrology, in groundwater characterization, groundwater remediation, environmental restoration, and surface water quality standards. And I currently support the laboratory's surface water quality standards program in their water quality team. In the past, I served as the technical lead for the groundwater monitoring program under the interim facility-wide groundwater monitoring plan conducted. I was the lead from 2007 to 2015. My role in development of this final use attainability analysis, I came on board in 2020 and I provided initial review of the draft use attainability analysis, which was developed by my colleague, now retired, Robert Gallegos at Los Alamos, working with Windward Environmental, our contracting consulting firm. I was very involved in the stakeholder outreach and participation and public engagement process for both the draft and the final use attainability analysis. And I co-authored responses to comments that we received on the draft UAA with my colleague, Matthew Segura, who will be presenting after me. And then Matthew and I co-authored the final use attainability analysis. Let's go over the location of Sandia Canyon at Los Alamos, just to give you some background. The Sandia Canyon is, the assessment unit is highlighted with the red oval, and it's basically in the north central part of the laboratory. The laboratory is delineated by the yellow shading here on this map. And Sandia Canyon extends through the perennial reach, which is 2.2 miles, and then on through an ephemeral section to the eastern part of the boundary, and then it continues on to the Rio Grande. And the entire canyon extends 11.3 miles. The assessment starts at outfall 001, and I'll provide you a little more information about that, and continues on down. Let's talk about the physical setting of Sandia Canyon. The photo on the left is a photograph of the outfall 001. As Ms. Dolan mentioned, Upper Sandia Canyon is perennial, but it's effluent driven. And the segment is currently classified under 20.6.4126. The flow is effluent dependent, with most of the flow originating from outfall 001, but also there are several other outfalls with some discharge, outfall 027 and 199. And I will later show a map to show you these locations. The releases from outfall 001 originate from the laboratory power plant, and they have occurred since the early 1950s. The outfall currently discharges approximately 191,000 gallons a day. And this discharge actually supports a wetland just downstream, 3.6 acres in size. And the photo on the bottom right is a photograph of that wetland taken last spring. And you can see the cattails in that wetland. The assessment unit extends 2.2 miles down Sandia Canyon and ends at Sigma Canyon, which comes in from the west, entering Sandia Canyon. Beyond Sigma, flow is ephemeral. So all of this water that's discharged to the perennial reach either dissipates through evaporation or infiltrates into groundwater. The flow in Sandia Canyon rarely reaches the Rio Grande, and we have gauging station data, which we will discuss later on, but it rarely reaches the Rio Grande except after significant precipitation events. And lastly, there are no fish in Sandia Canyon. This is a nice little graphic regarding use attainability analysis I got from the Environmental Protection Agency website. And I just want to go over it briefly. A use attainability analysis is a scientific evaluation of the factors that affect the ability of a water body to attain a designated use. And there are a number of factors that affect attainability. There's 6 that are listed in the regulations. They're shown on the bottom. And we will be focusing on factor number 1, which is naturally occurring pollutants. That'll be the focus of our use attainability analysis. These other conditions we won't be discussing. So the regulatory basis for our use attainability analysis, as I mentioned, is a structured scientific assessment of the factors that affect attainment. And under 40 CFR 131, a designated use, which is not an existing use, may be removed if the use attainability analysis demonstrates that the designated use is not feasible based on one of those 6 factors. And specifically, we will be focusing on naturally occurring pollutant concentrations that prevent the attainment of use. Temperature is actually considered a naturally occurring pollutant. And in New Mexico, according to the New Mexico Environment Department integrated reports, temperature is the most common cause of impairment in our streams and rivers in the state. In New Mexico, a third party may propose amendments to a designated use by petitioning the Water Quality Control Commission after performing a use attainability analysis. Let's go over the history of the UAA conducted for Sandia Canyon. As Ms. Dolan mentioned, in 2005, the Water Quality Control Commission adopted Upper Sandia Canyon Assessment Unit as a classified water of the state with the cold water aquatic life use and a segment-specific maximum temperature, we'll refer to that as Tmax, of 24 degrees Celsius. In 2007, the New Mexico Environment Department prepared a use attainability analysis to document the attainable recreational and aquatic life uses at Los Alamos National Laboratory in segments 126 and 128 waters. And the cold water aquatic life use was proposed for Sandia Canyon. The Environmental Protection Agency approved that UAA in September of 2007. In 2010, the Water Quality Control Commission eliminated the site-specific maximum temperature of 24 degrees for Sandia Canyon, and they replaced it with a general temperature criteria under NMAC 20.6.4900H. That has a Tmax, again, of 24 degrees Celsius, but an added chronic temperature, 6T3, of 20 degrees Celsius. And 6T3 is the chronic temperature limit not to be exceeded for 6 or more consecutive hours in a 24-hour period on more than 3 consecutive days. In 2014, Los Alamos National Laboratory initiated a temperature study to determine if the aquatic life use was being attained and to determine if naturally occurring thermal conditions prevent attainment of that cold water aquatic life use. And this study included placement of thermographs to measure temperature at select locations along the perennial portion of that reach. Shortly thereafter, in 2015, the laboratory notified the New Mexico Environment Department through correspondence, which is in our exhibits. Let's go back to where I was. Yeah. And so opening up communication with the Environment Department and Los Alamos National Laboratory, there's various written communications. NMAD provided guidance, and there were discussions regarding placement of the thermographs within Sandia Canyon. And the laboratory initiated development of a work plan in 2018. This was an iterative process, and there were several work plans that were developed before the final work plan in 2020. Now, the New Mexico Environment Department classifies the perennial reach of Sandia Canyon as impaired for temperature in the 2018 integrated report and then all subsequent integrated reports. In 2020, as I mentioned, we submitted the final use attainability analysis work plan, which was subsequently approved by the New Mexico Environment Department on April 9. So Upper Sandia Canyon is impaired for temperature. And assigned category of 5B, indicating that the designated use may not be supported and that a review of assigned standards is required to verify the appropriate aquatic life use. This use attainability analysis was conducted to determine the most protective attainable aquatic life use in the perennial reach of Sandia Canyon and to evaluate whether that cold water life use can be attained. This map shows the study area for the use attainability analysis. Sandia Canyon is in the center of this red rectangle, which is shown on the inset to the right and with regards to its position at Los Alamos National Laboratory. The perennial portion of the reach starts at outfall 001. And let me point out the 3 outfalls. If you see the inset in the top left of the map, there's outfall 001, and then just downstream is outfall 027. And in a fork that comes in just below is outfall 199. So these 3 outfalls provide the perennial water, effluent-driven perennial water. The perennial stretch extends from outfall 1 to number 6 here, which is where Sigma Canyon enters the canyon. Beyond that point, the flow is essentially ephemeral, and it rarely flows except after significant precipitation events. The red dots are the locations for the 6 thermographs that were deployed during the study. They were deployed over a 5-year period, and not all of them were for the full 5 years, but these locations were where we collected thermal data to evaluate for this use attainability analysis. Position 1 is right below outfall 001, and then they go on down through number 6. The final one is Sandia at Sigma. And my colleague Matthew will be discussing some of the data from these thermographs. I also want to point out the Llano meteorological stations. They're shown by the blue boxes labeled TA6 for Tech Area 6 and TA53. The real-time meteorological data collected from our MET stations was a valuable data source that was used to look at air temperature effects on water temperatures in the reach. So that information was very helpful. I also would like to point out the gauging stations. They're shown by the purple E designations in the rectangle, and they start with E121, 122, 123. These are within the perennial portion of the reach. And then there's two more gauging stations, 124 and 125 at the eastern end of the reach within the laboratory boundary. 124 and 125 rarely show flow at all. So all of the flow that we will be discussing, the data we're presenting is data collected from the perennial portion. The New Mexico temperature criteria for designated aquatic life uses are shown in this table, and we will be focusing on the cold water temperature criteria and the cool water temperature criterion. Cold water is the current designated use for the reach. It has a maximum temperature of 24 degrees C and a chronic temperature of 20 degrees Celsius. And the cool water designated use has a maximum temperature of 29 degrees C. And as I mentioned, the chronic temperature, 63, is the water temperature not to be exceeded for 6 or more consecutive hours in a 24-hour period on more than 3 days. Our work plan development was an iterative process. We started in 2018. We provided several drafts to the New Mexico Environment Department. They provided feedback, and we then finalized that work plan in 2020, submitted it to Environment Department in February, and it was approved in April of 2020. Now, the work plan utilized multiple lines of evidence to identify the most protective aquatic life use for the reach. I'm going to go over some of these lines of evidence, and then Matthew will be actually providing some of the data for these various lines of evidence. One of the keystones of our evidence, of course, is the actual data, the water temperature data collected from the stream. And we collected that information through thermographs, monitoring temperature on 15-minute increments during the study period. 5 years of data were collected from 2014 to 2018. We also used PRISM data. PRISM is a a meteorological data set provided by the Oregon State University Climate Group, and PRISM stands for Parameter Elevation Regressions on Independent Slope Models, and it provides gridded data for temperature all across the United States. But to complement that, we use the we use the laboratory's air temperature data from their meteorological network. The air temperature data and PRISM data were input into a correlation model developed by the New Mexico Environment Department in 2011 called the Air Water Temperature Correlation Model. The graph on the left sort of signifies that model. And essentially the premise is that the July average air temperature is approximately equal to the maximum weekly average water temperature in degrees Celsius. And they then provide equations that allowed us to calculate 63 and the maximum temperature. We used gauging station data, I mentioned that. And then we also looked at discharge volumes and temperatures from outfall 01. Additional lines of evidence include evaluation of impacts on threatened or endangered species. So we evaluated the area to see if there were any T&E species. And these include the willow flycatcher, the Mexican spotted owl, and the Jemez mountain salamander, and there are none within that area. Aquatic life surveys were conducted in the canyon. And then we also reviewed data that were regarding oxygen and pH measurements for the perennial waters at various locations in the reach. And we used a U.S. geological model as well to supplement the NMAC model, SS-TEMP. During the entire process, there was consultation and engagement with the New Mexico Environment Department and, of course, with the EPA as well. The initial correspondence regarding the study was started in 2015. when the laboratory reached out and to the Environment Department regarding the study, and the air water temperature correlation model was agreed upon to be used. In 2018 to 2020, we developed a work plan, and during the entire period from 2017 to 24, we had a number of meetings with the New Mexico Environment Department to discuss the use attainability analysis and later on the comments and recommendations that we received from the public comment, from the NMAC, and from the EPA. And in 2021, we submitted the draft use attainability analysis. We received these comments in 22, and then in 24, we submitted the final use attainability analysis. I will not read this table. This is in my written testimony. This is basically a summary of the multiple meetings we've had with our engagement with the New Mexico Environment Department back and forth, and the correspondence as well. The work plan specified a comprehensive stakeholder outreach and public participation process. And these requirements were followed. This process involved 2 rounds of public notice and comment and responses, one for the draft use attainability analysis, one for the final UAA. Comments emphasize the importance of measured model data, of measured data, the actual water temperature data over the model data, and encouraged ensuring protection of the downstream waters. And the final use attainability analysis recommendations were adjusted in response to the comments we received, and now maintain that cold water is, in the easternmost portion of the existing AU. During this stakeholder outreach process, we had numerous presentations. First of all, to the Northern New Mexico Citizens Advisory Board, or NNMCAB. We also had meetings with the Accord Pueblos, including the Pueblo de San Ildefonso, Santa Clara Pueblo, Pueblo of Jemez, and Pueblo de Cochiti. And we had several meetings with the East Jemez Resource Council. In these meetings, we presented the study, the data we were getting, and the plans for the UAA process. This is a similar table that's also included in my written testimony. This just shows the number of meetings we had with the various stakeholders in the public, including the various pueblos, our meetings to the East Jemez Resource Council, or the EJRC. And attendees to those meetings include several federal agencies, including the U.S. Forest Service, the National Park Service, the U.S. Geological Service, Army Corps of Engineers, also the New Mexico Environment Department, and DOE and LANL employees attend these meetings. I'd like to highlight the 2 yellow bands in this table. These are the time periods when the public notice process was conducted. The first one was for the draft use attainability analysis. It was initiated December 21 and ended in March of 22. And at that time, we did receive a fair number of comments. We took this as input. We revised the use attainability analysis and finalized it, reflecting the feedback we received. And then we had a final use attainability public notice process in May of 2024, but we received no further comments. Just briefly, I'll cover the public notice process. I mentioned draft and final UAAs were provided to the stakeholders. This public notice process included publication in 3 local newspapers, and also providing notice at the laboratory's electronic public reading room, which we refer to as the EPRR, and also our physical reading room. We had a physical copy of the use attainability analysis document. People could go to the reading room in Pewaukee and look at that. And then we have an email distribution service for related information called the Gov Delivery Service, and this was sent out to all interested members. I've already gone over the draft and final comment periods, and as I mentioned, we received comments on the first period, but not on the final. So in summary, I'd like to talk about what our recommendations are. Our findings showed that the current designated use of cold water aquatic life use is not attainable for the entire perennial reach of Sandia Canyon. And there's multiple lines of evidence that demonstrate this. Matthew will be going over that information. One of our findings was that air temperature has a very significant influence on stream temperatures in Sandia Canyon and the resulting attainable use. And our observations from the 5 years of thermograph data also showed that water temperatures are cooler in the lower portion, the easternmost portion of Sandia Canyon, due to various effects, orographic and microclimate effects. In this part of the canyon, it's more deeply incised in bedrock. There's large trees, there's a lot of shading, and the resulting temperature through the entire 5-year study, cold water continued to be attained in that stretch of the reach. So based on the data we collected and in the feedback we received, and we are recommending that the assessment unit be split into two, with the uppermost segment having the cool water aquatic life use. And this would be from Bedrock Road to Outfall 001. That segment will have a maximum temperature of 29 degrees, which is the standard Tmax for cool water. But also we're proposing additional protections. We're proposing implementation of a chronic temperature setting of 6 T3 of 25 degrees C. So we're adding that as additional. The lowermost portion of the segment, cold water, will continue to be maintained, and we propose to retain that cold water aquatic life use with a Tmax of 24 degrees C and a 6 T3 of 20 degrees C. And with that, that ends my testimony.
Thank you, Mr. Gehring. One last housekeeping issue with your exhibits. Is it correct that in addition to referencing exhibits submitted with the petition, your testimony references and cites to petitioners exhibits P through T?
Yes.
Petitioners would like to move for entry into the record of petitioners exhibits P through T.
Objections? They're admitted.
Thank you. We would like to call our second witness, please.
Ms. Dolan, I seem to remember some email correspondence about a necessary break
Yes.
around this time, and things may have changed. And I don't see Ms. Scott in the room. Ms. Scott, are you on the platform?
I am on the platform.
Okay.
I can speak to, just in case her connection is a little
Take
difficult.
a break, no need.
Okay.
Thank you, Ms. Scott. It's hard to make out your words. I think Ms. Dolan knows what you would say, though. Oh, yes?
So no need for an extended break on my part.
Oh, all right. Thank you very much, Ms. Scott.
Thank you. She elected to join on the platform temporarily.
Terrific. I think it's time for a break anyway, though. So let's break until 10:45. Thank you.
It was too late now.
Alrighty, when we took our break, we had completed the direct testimony of Mr. Garrett. I believe we're going to turn now to Mr. Segura's testimony, and then they will be questioned as a panel. Ms. Dolan.
Thank you, Madam Hearing Officer and Chair Thompson and Commission. We'd like to call Matthew Segura to be our witness.
All right, Mr. Segura, I'm sorry, would you spell your name, please, your first and last name?
Sure. First name, Matthew, Matthew, Segura, Segura.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Dolan.
Thank you. Mr. Segura, where are you currently employed?
I'm currently employed by Triad National Security.
And how long have you worked at Triad?
I have been at Triad since 2022.
Could you please describe your current role?
Yes, I work for the environmental compliance group with water quality standards.
And what are your duties?
We do field work activities, we sample, and we look at different compliance in accordance with NPDES.
Thank you. And would you please just briefly describe your educational qualifications?
Sure. I have a Bachelor's of Science in Biology, as well as a dual master's from the University of New Mexico in water quality water resources and community and regional planning, excuse me.
Mr. Segura, do you have before you what has been identified as Petitioner's Exhibit U?
Yes.
Do you recognize that as your curriculum vitae?
I do.
Is that document true and accurate to the best of your knowledge and belief?
It is.
Thank you. Petitioners would like to move for entry into the record of Petitioner's Exhibit U.
Objections? Exhibit U is admitted.
Mr. Segura, do you have before you what has been identified as Petitioner's Exhibit W? Excuse me.
Yes.
And do you recognize Exhibit W as your pre-filed direct testimony?
Yes.
Was this testimony prepared by you or under your direct supervision?
It was.
Do you have any corrections to your testimony?
Yes, there's one minor correction for Table 7 of the UAA. We had a couple of non-substantive corrections, just a few minor errors that didn't change anything, but I will go through that during my presentation.
Okay, thank you. If you were, is your testimony true and accurate to the best of your knowledge and belief?
It is.
If you were asked the same questions today, would you answer them the same way?
Yes.
Thank you. Madam Hearing Officer, petitions would like to offer Petitioner's Exhibit W.
Objections?
Okay.
W is admitted.
Thank you. And we'd like to go ahead and ask for permission to share from Tim Gering's entry into the platform.
It's just taking a second. I guess we're just having a technical difficulty here. So let's see. Okay, thank you for your patience. My name is Matthew Segura, and I will be going over my direct testimony on behalf of petitioners. So first, I'll go through my qualifications. We'll then go through how the UAA implemented the work plan. We'll then get into our water temperature analysis, looking at our thermograph data collection, the air water temperature models, and stream flow data. We'll also look at some additional factors affecting aquatic life, such as habitat and species analysis, as well as other water quality parameters. And then finally, we'll finish up with the recommended regulatory amendment. So I have like I mentioned before, I have a Bachelor's of Science in Biology, as well as a dual Master's in Water Resources and Community and Regional Planning, both from the University of New Mexico. I have over 8 years of hydrology experience with a focus on surface water quality and watershed management. I help support LANL's Surface Water Quality Standards program and help manage hydrologic data sets and field data collection. My role in developing the final UAA, I was a technical lead and co-author, as well as co-author of the response to comments, both to the public as well as to NMAC and EPA. And I co-led public meetings and stakeholder engagements since I was hired in 2022. So when we look at how the use sustainability analysis implemented the final work plan had the main objective to determine if natural thermal conditions are preventing attainment of a cold water aquatic life use. Several things we looked at were to analyze water quality data models, evaluate flow via the gauging stations, perform aquatic life surveys, compare the influences of the outfall with air temperature in the assessment unit, and provide public notice. And so the way the UAA executed this plan was, first, it found that air temperature is a major factor in preventing this cold water aquatic life use attainment. Our thermograph data show that cold water criteria was consistently exceeded, and our modeling showed that air temperature is a dominant factor in stream temperature regulation. Excuse me. DO and pH were within compliance and not limiting factors, and our biological assessments showed that no cold water sensitive taxa were observed. The outfall 001 has a limited influence on downstream waters in regards to temperature, with also limited flows beyond the LANL boundary. And NMAC, our stakeholders, different tribes, and the public were all informed at many major milestones. And so we'll now get into the water temperature analysis. First, we'll look at our thermograph data collection of in the stream temperatures. Then we'll look at some of the models, such as the AWTC, which is the air water temperature correlation, and PRISM, which is the parameter elevation relationships of independent slopes model. We'll then look at the MWAT analysis, which is maximum weekly average water temperature. And then we'll finish up with stream flow data. So quickly to go through the New Mexico criteria for aquatic life use. I know Tim had pointed out this with water temperature, but there are also other parameters we want to show. This is a shortened version of the entire designated uses, and we're just gonna really focus in on cold water. And then we're gonna show the comparison between our proposal for the 141 cool water with what cool water would normally propose. So for cold water, we have a minimum dissolved oxygen standard of 6 milligrams per liter. We have a 6T3, so that's that chronic temperature standard of 20 degrees Celsius. And again, just to remind everyone, it's the 6-hour consecutive temperature over a 24-hour period that occurs for more than 3 consecutive days. So it cannot exceed that 20 degrees for those more than 3 consecutive days. It also has a temperature maximum of 24 degrees Celsius and a pH range of 6.6 to 8.8. Now with cool water, we have a DO minimum, a dissolved oxygen minimum standard of 5 milligrams per liter. And typically you do not have a 6T3 or a chronic temperature standard with cool water, but however, in what we're proposing this extra protection, this 25 degrees Celsius of a 6T3 criterion. It has a 29 degrees Celsius temperature maximum and a range of pH from 6.6 to 9. You guys have seen this map before, but we want to show our thermograph locations and just orient you all with our thermograph locations. So starting at number 1 in that upper left window, you can see that's below outfall 001. As you move downstream, we have number 2 at below surf. And then below the wetland, we have number 3 at E123. And then directly below that, we have number 4 at below E123. And then as we zoom out, you can see number 5, and it has that picture in that lower window on the left, and that's Sandia at Bedrock Road. And finally, at the end of our assessment unit is Sandia at Sigma Canyon. It's also important to point out where the wetland is. So in that upper window, you can see in the lime green, we have the Sandia wetland, and directly below that, we have the Sandia grade control structure that went in in 2014 to help stabilize the wetland. So this is an overview slide showing water temperature variation within our assessment unit. We will zoom in on this data a little bit more closely in the next couple slides, but we just really want to show you again what we're looking at. So from upstream, the upstreammost location at below outfall 001, moving downstream to Sandia at Sigma. And these graphs all represent our thermograph data collection. A thermograph is basically a meter that we put in the stream, and it takes long-term, it collects data on long-term. And for this specific study, we looked at 15-minute increments. So every 15 minutes, it's recording the temperature of the stream. And so as you can see, these are thousands of data points over the 5-year period, and just want to highlight that. And so there's kind of this natural break in the system where the upstreammost locations are not meeting this cold water criteria. But as you move downstream to the very bottom below that red line, you're seeing it generally meets the cold water criteria. Those two locations highlighted in the light blue kind of represent a transitional zone. So some years you'll see cool water, some years you'll see cold water. But in general, we are seeing kind of this non-homogeneous water in the system. And this is figure 3 of the UA, the final UAA. So now let's look a little bit more closely at the data. And this is that uppermost portion, again, looking from upstream at below the outfall, downstream to right below the wetland at E123. And so this shows the cold water exceedance here. On our y-axis, we have temperature in Celsius, and then x-axis is our date time broken out by each summer month that we collected data. So if we look at the top below the outfall 001 in 2014, we can see that generally the water coming out of the outfall is generally cool water. But as you move downstream to below SURF in 2014, and then to E123 in 2014, you see that the temperature rises quite rapidly. And E123 actually breaks the cool water Tmax of 29 degrees Celsius during that year and only meets a warm water criteria. Then if we move over to 2016 at below the outfall, you can see again, the water is coming out as cool water, but as we move downstream, we are seeing that water temperatures warm up. And then in 2016, it's a little bit different. Between June and July, you're seeing some warmer temperatures coming out of the outfall, but as we move downstream to below SURF, and then E123 in 2016, you're seeing the water cool off. And this just really points to the fact, so based on this data collection, we're seeing that the outfall is not really the primary driver of stream temperatures, and air temperature is kind of this main driver, especially as it equilibrates downstream. Now let's keep moving downstream. This is below E123, below the wetland, and it's kind of, this one's in that transitional zone, but it generally meets cool water Tmax, temperature maximum. And then as we move to the very bottom of the reach, Sandia at Sigma Canyon, we see that it's generally, or it is meeting cold water Tmax based on the 6T3 and temperature maximum. And so 2 points to just drive home is that we are seeing that the outfall is not the primary driver of water temperature here. We are seeing that air temperature is kind of that main driver, and Sandia at Sigma Canyon is meeting a cold water criteria every year of the study. Now we will go into this thermograph data attainment summary. So on the left, again, we have from the upstreammost location of our thermograph stations moving downstream, and that's broken out by each year from 2014 to 2018. To generate our Tmax and 6T3 values, we took that data and we cleaned it up and made sure it was in the right format. And we used the New Mexico Environment Department's long-term data management spreadsheets. So this 15-minute data was our input. And when you run the calculation sheets, you get a temperature maximum and a 6T3 for the year, as well as some other parameters. But these are the main focus for our designated use attained. And so we can see that on the right-hand side, you generally see what we just talked about with the data is that generally you're meeting a cool water criteria upstream, and as you move downstream, we meet a cold water aquatic life use criteria with several years only meeting a warm water aquatic life use. We also want to point out that The cool water highlighted in the mint green also meets marginal cold water based on TMAX and 6T3. But based on the 2020 triennial review and their subsequent technical support document that the EPA released, this is a direct quote, marginal cold water in reference to aquatic life use means that natural conditions severely limit maintenance of a cold water aquatic life population during at least some portion of the year. And so we're taking that natural conditions to be the keyword there. And so based on this, LANL understands it to mean that marginal cold water would not apply to our system, to the perennial reach, based on the fact that it's not natural, it's anthropogenic in origin coming from the outfalls. And next we want to look at some of our modeling. So first we'll look at the air-water temperature correlation model. This is a model taken from the New Mexico Environment Department in 2011, and we used it to evaluate attainable use for Upper Sandia Canyon. We looked at several different data sets such as PRISM, looking at mean air temperatures and elevation. We also used our LANL meteorological stations at TA6 and TA53, and also 5 years of thermograph data from 2014 to 2018. And our modeling results show that cold water aquatic life use is unattainable based on air-water temperature correlation. This map here on the right is an elevation map, and it shows where our meteorological stations are located. We have TA6 over here in the westernmost portion and TA53. These arrows are pointing to where Sandia Canyon is located. And these blue lines represent the different polygons that we use for our PRISM modeling. And so to get into PRISM, again, that's the parameter elevation relationships of independent slopes model. It's a lot to say, but so this was adapted from table 7 of the final UAA. And with PRISM, we look at these different 30-year normals. So for our study period, we looked at the 1991 to 2020 year normals. We also looked at 10 years prior to see if there were any differences with the studies in the 80s to see if maybe the 80s were warmer or something like that. And then we also looked at a smaller subset, a smaller headwater grid. Typically, you look at a 4-kilometer grid, but we really wanted to focus in on the headwaters of Sandia Canyon, and it kind of excludes some of the mountainous areas since our water isn't coming from the mountains. So with PRISM, you generate an average July air temperature known as ATEMP, or those 30-year normals. You then take that, that number you generate and you plug it into the AWTC equation to generate a 6T3 and a TMAX, and those equations are listed down below. And then based on the 6T3 and TMAX, we have one both for the AU West and the AU East, those two different PRISM polygons that I had showed you. You generate a projected attainable use highlighted here in the pink. And you can see that no matter if we use the 1991 or 1981 or the headwater grid, we came up with the same conclusion that the projected attainable use is marginal cold water or cool water. This table was where I made a correction. We had some of the numbers here switched up in the headwater grid. We had them listed in the AU East and not the AU West, and the headwaters are in this AU West grid. And we had a couple minor corrections with the second decimal point in generating 6T3 and TMAX, but overall they were non-substantive because it came to the same conclusion here. Next, we want to look at AWTC, our air water temperature correlation model, on a year-to-year basis. And we know that PRISM looks at these 30-year normals, but we were interested in looking on a year-to-year basis to see, maybe if some of these years could be outliers or they could be a particular warm year or something like that. And also our MET data, or our meteorological station data, shows actual data that's collected on LANL property versus PRISM, which uses these interpolations from various landscapes and elevations from a faraway weather station. So we thought this might be more appropriate to look at on a year-to-year basis. And again, so what we did was, for using our different meteorological stations for TA6 and TA53, we were able to figure out the average July air temperature for each year. We then plug that into the AWTC equations to generate a 6T3 and a TMAX, and that gives you your projected attainable use here. And we can see that generally it meets cool water, with some of the years meeting warm water. And I just also want to point out that our meteorological station TA53 is a lot lower in elevation, so that could be a potential reason as why we're seeing warmer temperatures for projected attainable use there. Next, for the maximum weekly average water temperature, MWAT, we use the same equations from NMED, but instead of using the average July air temperature, we use this MWAT, which takes our thermograph data and averages it over time. And so the MWAT value is calculated from actual in-stream collections. And based on this, we found that MWAT data suggests that cool water aquatic life use is typically attainable for Upper Sandia Canyon. So if we look at this table on the right-hand side, or on the left-hand side, we have our stations from upstream to downstream, broken out by each year. And again, the measured MWAT is calculated using values from our thermograph locations. And so those are averaged over each day. And then we kind of take a 7-day rolling average and calculate it over the warmest month, which is July. And so that's those max values are what you get for MWAT here. We then took those measured MWAT values and plugged it into the AWTC listed below to generate a 6T3 and a Tmax. And for the predicted attainable use, you can see that it generally meets cool water, with some of the lower stations meeting cold water. And it's also important to point out the ND stands for no data. We had a thermograph that was exposed to air temperature, and we weren't able to calculate those rolling averages. So next, we talked a lot about air temperature and water temperature, and we just want to zoom in a little bit more and explain how air temperature is affecting water temperature. So we're looking at below E123. This is kind of the bottom of that segment that's meeting a cool water aquatic life use criteria. It's in that transitional zone, and we'll focus in on July of 2017 here. And so what this graph shows is a comparison of water temperatures. First, we have our thermograph in the light blue, which is below E123, and then in the dark blue is our outfall 001 water temperatures. And we're comparing that with meteorological station TA6, average daily air temperature in the light gray dotted line. Again, you have your cool water Tmax at 29 degrees Celsius. You have, and that's depicted by the red line. Our orange line shows the cold water Tmax at 24 degrees Celsius. And our cold water 6T3 is the red dotted line at 20 degrees Celsius. And first of all, when we're comparing this, what we can see is that there are these diurnal temperature variations within our stream temperatures. So at below 123, you can see that, during the day, it goes up with the air temperature and then it cools off at night. And that gives you those diurnal temperature swings. And when you compare that with outfall 001, you're not seeing that, since it's an outfall and it's manufactured water. Another thing to point out is that the in-stream temperatures get warmer than the outfall on most days. And that really points to temperatures being more of a limiting factor as compared to the outfall. And so it's especially apparent when you compare that to the TA6 average daily air temperature. And you can see that, as average daily air temperature is going up, you can see that the stream temperatures go up. And then as it goes down, it follows that trend line down, whereas the outfall does not. And so we point to this as being, showing that air temperature is the main driver of in-stream water temperature as you move downstream. Now we want to look at kind of our last Sandia at Sigma, our last thermograph location in that cold water segment. And we're going to look at the same time period, July of 2017. And you can automatically see the difference here. So the only difference is that the light blue is now Sandia at Sigma Canyon. And you can see that the temperatures downstream are much cooler. And that point, as Tim Gehring pointed out, that is apparent when you look and you see that there's a lot of shade. The canyon is more incised. It's a steeper canyon. But in general, it still follows the average daily air temperature trends. Next, we want to just walk you all through our different locations for our gauging stations. And so if we start again at the top, we have E121, which gets most of its flow from outfall 001. We have E122, which gets most of its flow from outfall 199. As we move downstream below the wetland, we have gauge E123. And then as we move out past our assessment unit, past Sandia at Sigma Canyon, we have E124. And then at the very bottom of laboratory property, we have E125. And it's just important to point out these distances. It's about 2 miles from E123 to E124. It's another 2 miles to E125, and then another 4.5 to 5 miles to the Rio Grande. And so this graph really helps us understand the limited effects of flow to downstream waters. In the upper perennial portion, you can see that there's a lot more flow occurring. So if we look at this graph, we can see that on the y-axis, we have average annual flow in acre feet per year. And on the x-axis, it's moving from in the flow direction. So from upstream gauges to downstream. And this is average annual flow from water year 2012 to 2021. So almost 10 years of data. And this graphic is taken from N3B's annual surface water reports. And so the blue really depicts this perennial portion of Sandia Canyon. And you can see that at E123, if we total all this up, coming out of the outfall 001, we are seeing about 75% of that water being from outfall 001, and then about 15% coming from 199 or E122 gauge, and then about 10% of that being runoff from storm events. And then if we look past E123, past our assessment unit, we see that that water rapidly declines, and that's due to it going subsurface and evaporation, and also the canyon opens up again. So several different factors, but it just really shows the limited flows downstream past our assessment unit. Again, there are significant distances between the upper gauges and the lower gauges at the laboratory. And it's important to note that just because you see flow events at maybe some of these lower gauges does not mean that it's a flow event occurring. You know, it's not that you have precipitation happening upstream and it's flowing. It could be, but it could also be a more localized event, and that's important to just note there. And then last, our protection of that cold water aquatic life use at the bottom of our assessment unit is also this extra protection of downstream waters. Other factors we need to think about are dissolved oxygen and pH. And those were within the acceptable range for the study period, indicating no related impairments. However, it is important to point out that they were from our interim facility-wide groundwater monitoring plan and their quarterly grab samples. We also looked at threatened and endangered species. So no federally or state-listed aquatic species were found in Upper Sandia Canyon Assessment Unit during these biological surveys, and the proposed reclassification will not affect habitat or endangered species. Now we want to look at this other map, and this really shows what we are proposing here. So we look at the upper portion of this map, we see our current stream designations, and this is currently cold water, the 126 waters, all the way from Sandia at Sigma up to outfall 001. And what we are proposing is this lower map here, in which you can see the stream segment is split from Sandia at Bedrock Road, number 5, all the way up to number 1 at outfall 001. And that would become a new cool water designation with that extra 63 protection. And then the remainder of the assessment unit from number 6, Sandia at Sigma Canyon to Sandia at Bedrock Road, would retain that cold water aquatic life use. And this is just our proposed amendment. And what we are proposing is to split the Upper Sandia segment to establish this new cool water aquatic life use from Bedrock Road to outfall 001. It'll have a temperature maximum of 29 degrees Celsius. And then this chronic extra protection, the 63 of 25 degrees Celsius. And then the lower portion would retain the cold water aquatic life use from Sigma Canyon to Bedrock Road. And we'll show you the language in the amendment on the next slide. Now, this is our proposed amendment from Los Alamos National Labs. And the red is our highlighted changes. So I will let you all read that. But again, it is our proposed regulatory change from LANL, and we are aware that the New Mexico Environment Department may have some non-substantive changes to language and format and things like that, and we are definitely okay with that. And so in summary, our results show that the cold water aquatic life use is not supported through the entire reach due to these natural air temperature conditions. Our measured data show exceedances of cold water 63 and or TMAX at most thermograph locations, except for that lowermost portion at Sigma Canyon. And our model data support cool water or warm water. So based off of these results, we recommend splitting the reach, where the upper segment is a cool water aquatic life use with a 6T3, this extra 6T3 criterion on 25 degrees Celsius, and then the lower segment would remain cold water. There are also some environmental considerations we want to highlight, is that air temperature predominantly drives stream temperatures. And so cooling at the outfall may not reduce downstream temperatures, and that requires a significant amount of energy input. And last, the proposed amendment protects aquatic life and maintains the cold water designation in the lower segment, reaching that highest attainable use. And I'm now done with my slides.
Thank you. And Madam Hearing Officer, Commissioners, Chair Thompson, we'd like to open up for questions.
Thank you, Ms. Dolan and Mr. Segura. Ms. Scott, do you have questions of petitioners' witnesses? All right. Mr. Maxwell, do you have questions of petitioners' witnesses?
No questions, Your Honor.
Thank you. I believe we have one or two commissioners online. Commissioner Harms, are you still with us online? She's not. Commissioner Borunda, do you have questions of petitioners' witnesses?
No, ma'am. I have no questions. Everything seemed to be answered in the second presentation for me. Thank you.
Thank you very much. I'll turn to the commissioners on the panel. Commissioner Moander.
No questions, Madam Hearing Officer.
Commissioner Langer.
No questions.
Commissioner Laney.
No questions.
All right. Commissioner Frowdy.
No questions.
Commissioner Zemlich.
No questions.
Mr. Chair.
Yes, I have questions. It's only one question. A couple of years ago, I got involved in an effort by the New Mexico Bureau of Geology to look at the impacts of a changing climate on water resources. And I wrote 2 chapters in it. One chapter was the effect on water quality. And as you have both pointed out in your testimony, temperature exceedance is the major cause by a bunch for non-attainment in various reaches of our streams. And it's going to get worse, unquestionably. Now, you have done some really nice work, and I congratulate you. It's excellent work. And I was very, very impressed. But you are proposing a standard for 6T3 that does not exist for cool water. And I want to know why. And I'll tell you, the reason I'm a little bit not necessarily concerned, but I wonder if it sets a precedent for future use attainability analysis for stream segments that are not in compliance with stream standards. So in short, my question is, why are you proposing the 6T3 standard? And the second question is, does that set a precedent that is going to be challenging to meet in future use attainability analyses?
Yeah, so the 6T3 proposed of 25 degrees Celsius is above and beyond what the cool water aquatic life use criterion is. And this was basically recommended. We met with, we took comments from the public, from the New Mexico Environment Department, and from the EPA. And this was reflected some of the input received. We met with the New Mexico Environment Department, and we agreed that additional protections could be applied in imposing that 63. So it was basically some collaboration with NMED, and then we wanted to go above and beyond just cool water and apply that. Regarding setting a precedent, I can't really speak to that, but anything you do can set a precedent. So I'll leave it at that. Matt, did you want to add anything?
No, just based off of what Tim said, yeah, we originally in our first draft of the UAA, we had proposed cool water, and we got a lot of pushback from just proposing cool water. So we added this extra protection as reflected by the comments.
But let me caveat that. The first draft, I think, proposed cool water for the entire reach. Mm-hmm. And we wanted to be protective and have the highest attainable use. And we clearly saw that cold water split. And so we you know, it's really clear that that attainable use is still protected through the entire study. So we wanted to split the reach and have a cold water, you know, retained in that lower section and cool water in the uppermost section.
But the lower section is ephemeral, isn't it?
No, the lower section of the perennial is the portion we're talking about, where we're splitting the reach. Okay. And there's different characteristics with cooler water in those lowermost thermographs.
Okay, great. Thank you. I appreciate it. I have no further questions, but I will ask the same question of the Environment Department when they provide their testimony. Thank you.
Thank you. Commissioner Bayless.
No questions.
Commissioner Brinkard.
Well, we need some questions here. So I may have missed this, but in the first testimony, they identified 3 outfalls. 001 is the power plant, and I didn't catch what the other 2 outfalls are. There's a 199 and a 27.
Yes. So 001 is the primary outfall providing the discharge for the perennial reach. And in our most recent year, I think 83% of the flow originates from outfall 001. The secondary, the second largest outfall, most significant one, is outfall 199. And outfall 199 is below the Strategic Computer Center in the next fork over. Correct me if I'm right. But that outfall produces about 15% of the flow. And then the third outfall is 027, and that's about 1%.
And you know what 027 is?
027 is from the it's at the Sanitary Effluent Reclamation Facility just downstream from 001. And yeah, it's basically a wastewater treatment facility that removes silica from the water to provide it for the laboratory's high performance computing center.
All right, thank you. I just wanted to get that kind of on the record. Yeah. And thanks for your explanation, because I was really struggling with the concept of that you were heading downhill, but the water was getting cooler concept here. My limited scientific brain, I'm kind of at the level of RFK Jr. in understanding science. So I noticed in your last slide that the segment is now divided between 141, 126, and then further down it's 128. Is that correct? That last slide?
Yes.
So yeah, 141, 126, and then 128.
Okay, so I guess maybe this is more directed to the Environment Department. They may want to do this at a future rulemaking, but if you go to 128, it refers to portions of, and it lists a bunch of canyons, including Sandia Canyon, without identifying the stretch of those canyons. And it simply says the portions of those canyons not identified in 126 or 140. I think in the future you may want to add or 141 to that provision, maybe in the triennial review or something to clarify that. So
thank you.
That's it.
Commissioner Behill?
No questions.
Mr. Chairman.
Thank you. I had one other question. 6 or 8 months ago, we amended the stream standard for copper. Does that include this stream as well?
Yeah, I believe so. I think so.
But
this wasn't evaluated in our UAA.
I understand.
Separate, yeah.
But it's the same stream, Sandia Canyon.
Thanks. It was just something that came up while I was reviewing some documents. Thank you.
Ms. Dolan, do you have any redirect or follow-up?
I do not. Thank you.
All right. Any reason not to excuse petitioner's witnesses? Thank you, Mr. Gehring and Mr. Segura.
Accept.
We have Ms. Scott and Mr. Baca at the table. Ms. Scott.
Madam Hearing Officer, Chair Thompson, and members of the commission, I'd like to call NMED's technical witness, Michael Baca. Please state and spell your full name for the record.
Good morning, Madam Hearing Officer, Chair Thompson, and members of the commission. My name is Michael Baca. That's M-I-C-H-A-E-L, and Baca, B-A-C-A.
And where are you employed?
Hold on. Mr. Baca, do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
And where are you employed?
I work for the New Mexico Environment Department.
And how long have you worked for NMED?
I've worked for the department for roughly 20 years, since February of 2005, in the environmental health, air quality, and now with the Surface Water Quality Bureau.
And what is your current role?
I'm part of the Monitoring, Assessment, and Standards section and serve as the Standards and Outreach Team Supervisor and the Water Quality Standards Coordinator.
What are your current job duties?
In this position, I lead the development, review, revision, and maintenance of surface water quality standards and supervise a staff of 3 consisting of a water quality standards scientist, our quality assurance officer, and our volunteer monitoring and outreach coordinator.
Please describe your educational qualifications.
I have a Bachelor of Arts in Chemistry from Carleton College.
Did you submit a copy of your resume as NMED Exhibit 2 in this matter?
Yes, I did.
And did you submit written direct testimony as NMED Exhibit 1 in this matter?
Yes.
Did you submit written rebuttal testimony in this matter?
No.
And do you have any corrections or changes to your written direct testimony?
No.
Do you adopt the remainder of your written direct testimony here today?
Yes, I do.
And can you provide a summary of your testimony, starting with providing some regulatory context?
Sure. My testimony will provide background on the framework for water quality standards, including designated uses and criteria, outline the administrative processes and procedures for standards amendments, and describe our collaboration and coordination efforts with the petitioners to review their technical work, proposed regulatory language, stakeholder engagement plans, and provide public notice of the rulemaking hearing on behalf of the Commission. A little background on water quality standards. State and federal statutes and regulations outline the requirements and regulatory framework for water quality standards and authorize states to adopt standards to protect public health or welfare, enhance water quality, and serve the purposes of the laws. The goal of the Federal Clean Water Act, as stated in Section 101A2, is to provide, wherever attainable, for the protection and propagation of fish, shellfish, and wildlife, and for recreation in and on the water. These are generally referred to as swimmable, fishable uses. Federal regulations direct states to set designated uses and criteria to protect those uses consistent with this goal. New Mexico's water quality standards are codified at 20.6.4 NMAC, and the designated uses set forth in Section 900 include fish culture, public water supply, industrial water supply, domestic water supply, irrigation and irrigation storage, primary and secondary contact, livestock watering, wildlife habitat, and aquatic life use, or ALU. The standards establish water quality criteria that protect the designated uses of a water body. These criteria can be general narrative criteria that apply to all waters, or numeric criteria that apply to a specific designated use or water quality segment. New Mexico's water quality standards include criteria applicable to all surface waters with a designated, existing, or attainable aquatic life use. This includes narrative criteria and acute and chronic numeric criteria. Federal regulations allow for states to adopt subcategories of designated uses to refine and clarify specific use classes. New Mexico has adopted 7 subcategories of aquatic life use, including cold water, cool water, and warm water aquatic life uses that have specific criteria for temperature, dissolved oxygen, and pH, in addition to the narrative and numeric criteria that apply to all aquatic life uses. Classified waters includes those waters that the Commission has adopted a segment description and has designated a use or uses and applicable water quality criteria. Sandia Canyon is included in Section 126 of the standards with a designated cold water aquatic life use with a maximum temperature criterion of 24 degrees Celsius and a 63 temperature criterion of 20 degrees Celsius. The initial classification of Sandia Canyon did not include a 63 temperature criterion, which was included as the result of a subsequent water quality standards amendment. Monitoring of the assessment unit resulted in the segment being listed in the 2018 to 2020 integrated report as temperature impaired with a category assignment of 5/5B, indicating a need to review its designated aquatic life use and criteria. The use attainability analysis is required for revising the swimmable fishable uses when removing the designated use or revising the designated use to include a less stringent criteria. A UAA uses scientifically defensible methods to assess the factors, including natural conditions, affecting the attainment of the designated use. UAAs that conclude a designated use should be revised or removed must also demonstrate the highest attainable use, or HAU, that is closest to the Clean Water Act, Section 101A2, swimmable fishable uses, based on the factors evaluated in the study. Third-party UAAs require proponents to develop a work plan that outlines the water body and reasoning for the UAA, the source of the data to be used to demonstrate the current designated use is not attainable, the 40 CFR 131.10G factors to be evaluated, the data to be used to determine the HAU, the state and federal agencies to be consulted, the stakeholder engagement and outreach process, the public notification process to be used, and the expected timeline, including any rulemaking activities that result from the UAA. Once a work plan is reviewed and approved by the department, the UAA may be conducted. Once the UAA is complete, the data and findings are then submitted to the department and public notice is provided to stakeholders in accordance with the work plan. If the UAA concludes that an amendment to a designated use and criteria is appropriate, the department or proponent may initiate the rulemaking process. Site-specific criteria must be developed based on a scientifically defensible method to reflect site-specific conditions. The Commission may adopt site-specific criteria based on relevant site-specific conditions like natural background or other physical, biological, or chemical factors. Site-specific criteria must fully protect the designated use to which they apply, and natural background must be determined by considering spatial and seasonal interannual variability as appropriate, documenting the presence of natural sources of the pollutant, quantifying the human contribution of the pollutant, and relying on analytical, statistical, or modeling methods to quantify the natural background. Rulemaking before the Commission begins when a person files a written petition and statement of reasons to adopt, amend, or repeal a regulation in accordance with 20.1.6.200 NMAC. The water quality standards allow any person to petition the Commission to adopt, amend, or repeal a water quality standard, including designated uses and site-specific criteria. The petition must also identify the specific waters to which the amendment would apply, explain the rationale for proposing the amendment, describe the stakeholder engagement process, present and respond to the public input received, and present the scientific findings of the UAA and derivation of the proposed criteria. If the Commission grants a hearing, notice of the rulemaking must be provided to the public in accordance with state statutes and regulations. The agency must distribute rulemaking information and provide public notice by publishing in the newspaper and in the New Mexico Register, posting information on agency websites, and contacting interested and affected parties. The public notice of rulemaking must include the subject, a summary, and the purpose of the proposed rule, the legal authority for the rule and its adoption, the technical basis for the proposed rule and how to find technical information, governing laws of procedure, and how to present and participate in the hearing, examine documents, and download information. In addition to publishing, the Commission must provide to the public notice of rulemaking by distributing information, by posting it on the Commission's website, posting it on the New Mexico Sunshine Portal, making it available at the applicable constituent agencies' district, field, and regional offices, sending it by email to people who have made a written request for notice of announcements addressing the subject of the rulemaking proceeding and who have provided an email address to the Commission Administrator, by sending it by email to people who have participated in the rulemaking and who have provided an email address to the Commission Administrator, sending written notice that includes at a minimum an internet and street address where the information may be found to people who provide a postal address, and providing it to the New Mexico Legislative Council Services for distribution to appropriate interim and standing legislative committees. If the Commission adopts new or revised standards at a public hearing, the Department submits those standards to EPA for review and approval. The Department worked with the petitioners to discuss expectations, develop a common understanding of requirements, and coordinate timelines and resources. As a result, the petitioners developed a work plan that included the technical analysis, stakeholder outreach and engagement, and government consultation to be conducted. NMAC reviewed and approved the work plan on April 9th, 2020. The Department and EPA provided feedback and comments throughout the planning and development of the UAA. Based on this early engagement, an initial draft UAA was developed and submitted to the Department for review. Additionally, the petitioners held a 45-day public comment period that ended on February 3rd, 2022, with an additional 30-day extension. NMAC provided formal comments on the draft UAA on March 4th, 2022. The petitioners addressed comments in a subsequent response to comments dated November 6, 2023, and revised the UAA dated February 16, 2024. The petitioners held an additional 30-day public comment period, but did not receive any comments. Throughout the process, the petitioners solicited input from the Department, EPA, stakeholders, and the general public, and also responded to all the input, feedback, and comments they received in their final UAA provided with the petition. The public notice for the hearing was drafted and published by the petitioners in the Los Alamos Daily Post, the Albuquerque Journal, and in the New Mexico Register. The department assisted the petitioners and commission with notification requirements and provided rulemaking information to the public by posting the notice of rulemaking information to the commission's website, the New Mexico Sunshine Portal, at NMAD's district and field offices, and by sending emails with the public notice of rulemaking and information to the Office of Public Facilitation and Surface Water Quality Bureau's listserv subscribers, the Legislative Counsel Service, and the Small Business Regulatory Advisory Council. Additionally, the department posted the public notice and rulemaking information on its events calendar, the Surface Water Quality Bureau's website, the NMAD Public Notice website, and we also created an entry on the department's public comment portal. In conclusion, Commission regulations allow for the revision of designated uses and adoption of site-specific criteria based on relevant site-specific water conditions and scientifically defensible methods when the amendments fully protect the designated use. The department and petitioners have worked collaboratively on a work plan, and NMAD considers the petitioners to have followed the work plan to develop and revise a UAA, complete stakeholder engagement activities, and respond to public comment throughout the process. The proposed revisions are based on scientifically sound approaches and methodologies, and NMAD considers the petitioners to have properly complied with the provisions of 20.6.4.10 NMAC and 20.6.4.15 NMAC. NMAD recommends that the Commission adopt the proposed amendments. If the Commission so adopts the proposed amendments, the Surface Water Quality Bureau would submit the revised water quality standards as published in the New Mexico Register to EPA for formal review and final approval action under Section 303C of the Clean Water Act. That concludes my testimony.
I'd like to move for admission into the record all of NMAD's exhibits.
That's exhibits 1 through 13. Objections? They're admitted.
And I'd like to call another technical witness to assist in answering commission questions.
All righty. See Ms. Guevara. If you would just be careful to pull the mic close to you as you share it. Yeah, good.
If you'd please spell your full name for the record.
Hello, Commissioners. My name is Lynette Guevara. To spell my last name, G-U-E-V as in Victor, A-R-A.
Ms. Guevara, do you swear or affirm to tell the truth?
I do.
Thank you.
Where are you employed?
I am employed at the New Mexico Environment Department Surface Water Quality Bureau. I am currently the program manager of the Monitoring, Assessment, and Standards segment.
And if you could briefly describe your educational qualifications.
I have a Bachelor of Business Administration from Gonzaga University and a Master's of Watershed Science from Colorado State University. I've been with the department for 24 years almost. Prior to being program manager, I managed the Clean Water Act 303D, 305B, integrated report and listing process.
Did you submit a copy of your resume as NMAD Exhibit 3?
Yes, I did.
Mr. Baca and Ms. Guevara are available for commissioner questions.
Great, thank you. Let's see, Ms. Dolan or Mr. Yoakum, do you have questions of Mr. Baca? No, I see head shaking no. All right, thank you. Mr. Maxwell, do you have questions of the department witnesses?
I have no questions for the witnesses. Thank you.
All right, thank you. Let's see, this time we'll start with Commissioner Vigil. Commissioner Vigil?
I have no questions. Thank
All
you.
right. Commissioner Brankard,
I have no questions.
Commissioner Bayless,
No questions.
Mr. Chair.
Thank you. And my question, I've already expressed it to the Lanel folks, the Triad folks. Why are we imposing a 6T3 for this stream segment? And the second part is, does that establish precedent? Do we expect to do a similar requirement for future streams?
Mr. Chair and Commissioners, as stated in the testimony and presentations by the petitioners, the Environment Department, specifically Ms. Lemon and myself, suggested that addition of the 6T3 because the 6T3 is a chronic temperature criterion. You can think of the maximum values as acute and the 6T3 and the 4T3 in cold water as chronic criteria. The history of the 6T3, 4T3, some of you might remember on the commission, we first used that technique as an assessment technique when we were assessing temperature data because we started deploying thermographs 20 years ago. It's a much better way to assess and monitor temperature. And then we proposed those to be included into NMAC, and the commission approved those. At a later date, we added an cool water aquatic life. And at that time, we hadn't done the research to propose any sort of 6T3. It's not to say that there shouldn't be one. We just haven't had the resources to do that work yet. So I applaud the petitioner's addition of that 6T3 because it provides additional protection, and the extensive data sets that they have, that as we witnessed in the earlier Triad petition and hearing, they have a lot more resources, have a lot more data to do that extra work, provides good evidence for why we should have that 6T3 because it is existing and can be met.
Thank you. So Lanel, based on the data that they submitted, they can comply with this. Is there a scientific basis for the 60, for the 24 to, is it 24? No, it's 20 degrees, 63. Is there a scientific, is there a physiological or biological or? Yeah.
As presented in their testimony, they use similar strategies and analysis techniques that we use with the air-water temperature correlation model. And it does show that using those measured data as well as PRISM data, and I think they also did a good job of showing warming temperatures by looking at the two different PRISM data sets, the two different 30-year averages. Shows that that can be met. So again, it is a goal. I believe it is a goal of the department. We would establish a 6T3 for cool water or some similar type chronic criterion when we have the resources and ability to present it up in front of this commission for approval. I don't believe what they're doing sets any form of precedent because this is a very specific UAA for a very small reach with significant data.
Yes, and I appreciate, and I don't necessarily, in fact, I don't at all disagree with the concept. I want to know why we picked 20, and then I want to know are other watersheds, particularly over in the eastern part of the state, will they be able to comply with the 6T3 20? And that, I'm asking for speculation, but my concern is, again, if we've done it once, 2 or 3 years or 5 years, when the next applicant proposes a UAA, are they going to be subjected to the precedent that we establish here?
Just one quick correction. The 63 proposed is 25.
I'm sorry, thank you.
And again, there is no relationship between pool water assigned to any other water and a precedent of a 63. This is all based on the analysis that they did and the recommendation that the department added or provided to say, you know, this can be met. You have the data to show it. You are showing it's existing. You should add this 63. That would add extra protection to this reach.
Again, it shows that they can meet it. Is there biological data, environmental data that shows there's a necessity for that standard? Or is it just a number that was kind of?
It is not a number pulled out of the air. It was the model analysis that they did and the data that they used to show it shows that it can be met. I guess I'm struggling to understand the concern.
Yeah, well, my concern is presumably most of the standards are established to protect either a specific species or a particular ecosystem or something like that. And does 63 of 25 degrees, can we document that that protects the environment? It's a tough question, and there may not be an answer. But I think as we go forward, if a new standard is proposed for cool water, or if another use attainability analysis, that's an obvious question.
Definitely when we proposed 63 for marginal cold water and for regular cold water of 43, we could look back in the record. We have all sorts of fisheries data that supported that, and that you need to, ideally you have a chronic criterion as well to protect aquatic life use. And as mentioned, when we introduced cool water, if my memory serves me, we did not propose anything like that because we just didn't have those data sets and analysis yet for the state as a default for pool water. But in this case, we have, you know, the petitioners have the data and ran all the analysis to make that proposal.
Okay, thank you.
Okay, Commissioner Zemlich.
Thank you. I don't have any questions.
Commissioner Fry.
No questions.
Commissioner Laney.
Yes, I do have a question, maybe just for record's sake, but just to be clear, is the department in agreement with the technical findings that were presented by the petitioner?
Yes, we are.
Okay, so there are no concerns that the impairment from it being cold water to now being cool water are at all related to any of the outfall waters that are feeding into the system?
That's correct.
Okay, thank you.
Commissioner Langer.
No questions.
Commissioner Moanda.
No questions.
Commissioner Burnda on the platform.
No questions, ma'am.
All right, thank you. Ms. Scott, do you have any follow-up or redirect?
Nope.
Is there any reason not to excuse department witnesses? Oh, thank you, Ms. Guevara and Mr. Baca. Let me invite public comment at this time. This would be non-technical public comment specific to this petition. Non-technical public comment. If you're in the room, just raise your hand. If you're on the platform, please raise your virtual hand. Okay. All right. Thank you all very much. At this point, we will close the evidentiary record, and I'll turn the floor back over to the chairman.
Thank you. And thank you to all parties. Those were good presentations and very helpful. So at this point, it's the commission. I think we can have a couple different possibilities. We can ask for a report from the hearing officer, or we can go ahead and proceed with a decision.
I believe that the request was that we not ask for the report from the hearing officer and that we then deliberate after this.
That
And
was their
I'm comfortable
request.
with that we request as well.
Okay, thank you.
Mr. Chair, I think we could probably proceed to a decision. That was 2 hours of testimony and presentation. Pretty succinct.
Okay. Does everybody agree? In that case, if we're going to proceed to a decision, perhaps it would be appropriate to have a motion whether to accept or deny the proposal or have further discussion. Mr. Brankard.
Mr. Chair, I move that the commission amend 20.6.4126 NMAC and add new subsection 20.6.4141 NMAC to establish a segment-specific temperature criteria for a portion of the Upper Sandia Canyon assessment.
Do I hear a second?
I second.
Commissioner Laney. Okay, it's been moved and seconded. Is there any discussion? Hearing none, are we ready to vote? Ms. Jones, could you call a roll, please?
Yes. Commissioner Barunda, how do you vote on Commissioner Brankard's motion?
I vote yes.
Thank you. Commissioner Brankard.
Yes.
Commissioner Fry.
Yes.
I don't think Commissioner Harms, are you on the platform? I don't see you. Okay. Commissioner Laney, how do you vote?
Yes.
Commissioner Langer?
Yes.
Commissioner Moender?
Yes.
Chair Thompson?
Yes.
Commissioner Bayless?
Yes.
Commissioner Vehil?
Yes.
Vice Chair Zemlik?
Yes.
Mr. Chair, the motion passes.
And again, thank you to all the parties. I know it's been about, 15 years, something like that, but it's done. Thank you very much. I would suggest that we take a break for lunch and we'll reconvene 1 o'clock and we'll proceed with agenda item number 7, which is WQCC 25-20, which is a request for review of a 5-year temporary standard for the city of Raton. Okay, we'll see you in a minute. Let's call this meeting back into session. I was kind of hoping Commissioner Brankard would join us, but we do have a quorum. So I am calling us back into session, and we are now going to hear agenda item number 7, which is WQCC 25-20, which was originally docketed as WQCC 19-46. It's a request for review of a 5-year temporary standard for the city of Raton. So I believe Ms. Scott is going to handle that.
Okay, good afternoon, Madam Hearing Officer, Chair Thompson, and members of the commission. Thank you again for being here today. My name is Brecken Scott, and I represent the Surface Water Quality Bureau within the Water Protection Division of the New Mexico Environment Department. The department is also here today on our request that the commission review the 20-year temporary standard that the WQCC adopted for the city of Raton, which is found in the New Mexico Administrative Code at 20.6.4.318 NMAC. The general manager for the city of Raton's water utility, Raton Water Works, is attending remotely over WebEx and can respond to commissioner questions. I will briefly provide some regulatory context and help situate you in this matter, which was originally docketed as a rulemaking as WQCC 19-46R. This review matter was assigned a new matter number of WQCC 25-20. The WQCC voted to adopt the temporary standard for Doggett Creek at the rulemaking hearing on March 10th, 2020, and the commission chair approved the temporary standard on July 24th, 2020, at which time it became effective. As you know, the Water Quality Control Commission is directed and required to adopt water quality standards for surface waters of the state under the New Mexico Water Quality Act. The Water Quality Act states, the standards shall at a minimum protect the public health or welfare, enhance the quality of water, and serve the purposes of the Act. Furthermore, in making standards, the Commission shall give weight it deems appropriate to all facts and circumstances, including the use and value of the water for water supplies, propagation of fish and wildlife, recreational purposes, and agricultural, industrial, and other purposes. The water quality standards include temporary standards, development and implementation of which are detailed at 20.6.4.10H NMAC. A temporary standard is defined as a time-limited designated use and criterion for specific pollutants or water quality parameters that reflect the highest attainable condition during the term of the temporary standard. New Mexico's temporary standards regulations are based on the EPA's federal regulation on water quality standard variances at 40 CFR section 131.14. If a temporary standard has a term longer than 5 years, it must be reviewed at a specified frequency, and the results of such reevaluation must be submitted to EPA within 30 days of completion. The language of the City of Ratone's temporary standard sets out a reevaluation period, which consists of a review every 5 years by the Commission, a review at every triennial, and a review at National Pollutant Discharge Elimination System, or NPDES permit renewals. The NMAC further states, if the reevaluation is not completed at the frequency specified, or the department does not submit the reevaluation to EPA within 30 days of completion, the underlying designated use and criterion will be the applicable water quality standard for Clean Water Act purposes until the department completes and submits the reevaluation to EPA. The 5-year review of the Doggett Creek temporary standard does not involve any public input or notice requirements. The temporary standard language itself under the NMAC states, public input on the reevaluation will be invited during NPDES permit renewals or triennial reviews as applicable, in accordance with the state's most current approved water quality management plan and continuing planning process. The 5-year review today is not a NPDES permit renewal or part of a triennial, so there is no applicable public input requirements to be met ahead of the Commission's review today. The temporary standard for Doggett Creek states, if the discharger cannot demonstrate that sufficient progress has been made, the Commission may revoke approval of the temporary standard or provide additional conditions to the approval of the temporary standard. It is NMAC's position that at the 5-year mark, the City of Ratone has demonstrated it has made sufficient progress in regard to the temporary standard. NMAC based its position from coordination between its technical staff and City of Ratone staff, and from the documentation provided by the City of Ratone. NMAC filed this documentation with the WQCC, which included a detailed cover letter regarding the city's operational changes, efforts made to secure financial assistance, and analytical laboratory results. With me today is Shelley Lemon, Bureau Chief for the Surface Water Quality Bureau. She will now provide a brief presentation for the WQCC's consideration and will be available to answer any questions the commissioners may have. NMAC respectfully requests that the WQCC discuss the progress made by the City of Ratone immediately following the presentation. NMAC respectfully requests the Commission discuss and vote on whether the City of Ratone has made sufficient progress immediately following NMAC's presentation. If the Commission finds that sufficient progress has been made, it can approve the temporary standard as is, or approve the temporary standard as is with the addition of the updated proposed actions and implementation schedule recommended by the City. If the Commission does not find that sufficient progress has been made, it can revoke the temporary standard, and the City would be required to meet stringent end-of-pipe limits for nutrients. Or it can request NMED amend the temporary standard to include additional conditions at the triennial, for example. Finally, NMED respectfully requests that the Commission memorialize its review and findings in a resolution or similar document. Thank you for your time and consideration in WQCC 25-20.
Good morning, Mr. Chair and Commissioners. My name is Shelley Lemon. I am the Surface Water Quality Bureau Chief for the Environment Department. And as Ms. Scott said, I'm here to give you an update on the discharger-specific nutrient temporary standard for the City of Raton's wastewater treatment plant. So for today's update, I'm going to provide some background on nutrients and why we're talking about nutrients, what is a temporary standard, and then the history of Raton's temporary standard, and also the reevaluation of the temporary standard, and then our recommendation for action today. So nutrients are one of the leading causes of water quality impairment in New Mexico's waters. According to the state's 2024-2026 integrated report, nutrients are impairing 1,209 miles of rivers and streams in New Mexico. Nutrient pollution in water bodies results in large daily swings of dissolved oxygen, which can change aquatic community dynamics. In some cases, these changes can result in nuisance algal blooms that lead to fish kills and other harmful effects, such as harmful algal blooms, can considerably reduce recreational opportunities and taste and odor problems for drinking water. So New Mexico has a narrative plant nutrients water quality criterion, which is stated on this slide. It's found in 20.6.4.13e NMAC. And in order to assess our water and our water quality in our rivers and streams, the Environment Department uses numeric translators or thresholds to assess the quality of our waters. We also use them to establish targets for total maximum daily load documents, and we use them to develop water quality-based effluent limits for NPDES permitting and other source control plans to support the designated uses in our water bodies. For Raton, the discharge is to Doggett Creek, which is exceeding the threshold values for total nitrogen and total phosphorus that are circled on this slide. As you can see, the total nitrogen threshold value is only 0.69 milligrams per liter in stream, and the total phosphorus threshold is 0.061 milligrams per liter in stream for total phosphorus. So effluent limits, if we were just basing them on the narrative standard and these thresholds, would probably be end of pipe compliance with these values and these concentrations because it is an effluent dominated stream. As noted on the previous slide, nutrient concentrations necessary to protect water quality are very low and result in permit limits that are not economically or technologically achievable for many permittees. Typically, there's little to no dilution in New Mexico streams, which means that our wastewater treatment systems are required to meet stringent limits. So in Raton's case, we needed to create a clear path to compliance that is achievable and affordable in the near term, and also encourages incremental improvements to water quality in the medium to longer term timeframes. And a temporary standard provision was added to the state of New Mexico's standards for interstate and intrastate surface waters during the 2013 triennial review. The proposed amendment was approved by the Water Quality Control Commission on January 10th, 2017, and by EPA on August 11th, 2017. Temporary standards, the intent of a temporary standard is to provide an adaptive management approach to address excess nutrients. This slide provides some history of the Raton wastewater treatment plant and Doggett Creek and our nutrient impairment. So Doggett Creek has been impaired for nutrients since the mid to late 1990s. It's been a long time. NMAC drafted a total maximum daily load in 2011, but it was tabled due to concerns that the waste load allocation based on those thresholds that I showed you would be unachievable. And NMAC was directed to work with the New Mexico Municipal League to develop alternative limits. The work group devised a strategy for alternative limits in NIPD's permits, but EPA struggled with the idea because there was no regulatory trigger or mechanism for EPA to require those alternative limits in a NIPD's permits. So the department went back. We incorporated the temporary standard provision into the triennial review process, which the commission approved in 2017 to provide that regulatory mechanism for alternative effluent limits. And the WQCC and EPA approved the Raton's wastewater treatment plant discharger specific temporary standard in 2020. So it's been a long road. The temporary standard, this is what it looks like in NMAC. And I want to point out a couple things. The first thing is it's, segment 318, 20.6.4.318 is specific to Doggett Creek. And as you can see in paragraph C, we have the discharger specific temporary standard that applies to Doggett Creek. The discharge is identified, the receiving water body is identified, the pollutants are total nitrogen and total phosphorus, and the factor of issuance. So the temporary standard has to be based on a certain factor, and the factor that was used was that substantial and widespread economic and social impacts would happen to the city of Raton if they had to pay for the treatment, which is reverse osmosis, to meet those stringent threshold values or limits. So that factor was provided in a demonstration that the department provided in 2020 to get this temporary standard approved. And we were evaluating whether there would still be social and economic impacts to the community if they were to implement reverse osmosis, and also looking at the highest attainable condition if they still apply for those interim effluent limits. So going to the highest attainable condition for Raton's wastewater treatment plant, what is in the temporary standard is 8 milligrams per liter total nitrogen and 1.6 milligrams per liter total phosphorus, expressed as 30-day averages. And so these values are the highest attainable condition for this temporary standard. That does not mean that they have to meet these conditions right now. The temporary standard is a 20-year temporary standard. They're working towards achieving these goals based on their current treatment system and optimization of the facility. So as Ms. Scott said earlier, our reevaluation period has to occur at least once every 5 years from the effective date, and public input on the reevaluation will be invited during the NIPD's permit renewals and also the triennial review process. If Raton cannot demonstrate that sufficient progress has been made to the commission may revoke approval of the temporary standard or provide additional conditions to the approval of the temporary standard, which would likely require a rulemaking depending on those conditions. So our reevaluation of the temporary standard, like I mentioned, we evaluated if any of the conditions, social and economic conditions of Raton have changed since the temporary standard was approved. And basically what we found since 2010, Raton's population has been steadily declining. In 2020, when the temporary standard was approved, there was 6,041 people. Today, well, in 2023, there's now 5,978, so 50 fewer households, no, more than that. Approximately 60% of that community is Hispanic, and the median household income is just over $52,000. If you compare that to the statewide median household income, that's $62,125, and the national MHI is $80,000. So overall, wages for jobs in Raton are generally less than wages at the state or national level. If you look at sewer rates for today, what is being implemented with the treatment system today compared to what a reverse osmosis treatment system would require, you're looking at $400 today versus $1,430 with reverse osmosis. Those are annual amounts, but 0.8% median household income versus 2.8% median household income. So that's a pretty substantial increase to the community. Almost all households and businesses in the community pay for wastewater treatment. And so an increase in any wastewater treatment rates would apply to almost the entire community. So requiring the City of Raton wastewater treatment plant to meet the existing in-stream nutrient thresholds would still cause substantial and widespread economic and social impacts. So this has been unchanged. It may be a little bit worse with the declining population, but it hasn't changed in the positive. For the highest attainable condition, the highest attainable condition is expressed as target effluent concentrations, and those target effluent concentrations should be achieved without causing substantial and widespread economic and social impact. The highest attainable condition reflects the greatest pollutant reduction achievable, again, without causing that widespread and substantial impact. For the City of Raton, there are the table on the slide shows the highest attainable interim effluent conditions. As I mentioned previously, the 30-day average concentrations are 8.0 for total nitrogen and 1.6 for total phosphorus. Those are what is in the current NPDES permit for the City of Raton. The long-term averages is what we based the highest attainable condition on. Those long-term averages are 5 milligrams per liter total nitrogen and 1 milligrams per liter total phosphorus. There is a conversion to from those long-term averages to the 30-day average that were in the original demonstration. So we did look at the treatment technology that they currently have and what is achievable if that treatment system is optimized to its fullest. And those were the long-term averages that we converted to 30-day averages. So considering the social economic impacts, this highest attainable condition expressed as 30-day averages are still unchanged. The data graphs that are shown, the total nitrogen is on the upper left, total phosphorus is on the lower right. Those are the 30-day average values from their current NPDES permit. We pulled data from January of 2022 when the permit was implemented to March of 2025, which was the last full month where we had data reported. The orange lines are the limits expressed in the NPDES permits. On the total nitrogen side, there are two different limits. There was a limit at the beginning of the permit term for the first year. And then the lower line is the permit limit that exists today, which is a little bit lower to try to, again, make those incremental improvements over time to try to achieve that highest attainable condition. So the data, you can still see there are some blips above those effluent limits, and the 3-year average for total nitrogen is 5.48 milligrams per liter. So that long-term average is approaching that 5 milligrams per liter. For total phosphorus, it's 2.09 milligrams per liter for that 3-year average. We still have a ways to go before we hit that 1 milligram per liter for the long-term average. All right, so in a report that the department has that's referenced in the temporary standard in 20.6.4.318 NMAC, we have an implementation schedule for actions and target completion dates. And we've updated this schedule to include some of the things that the city of Raton has done. It is broken out into phase 1, which is the first 10 years of the temporary standard, and phase 2, which is the second 10 years of the temporary standard. In phase 1, the city is incorporating chemical addition into its treatment scheme, and pilot testing of the coagulant addition for phosphorus removal will determine the type of coagulant that they will use. And based on that coagulant that's selected, the existing solids handling system might require additional attention to determine its ability to handle increased chemical sludge, including impacts to the effective treatment volume of the aeration basins. I know this is like really, well, somewhat technical, but if you add a coagulant, you're going to get more solids that you have to deal with, and the solids will take up the aeration basin, so you won't have as much space to inject air into it to help with nutrient removal. So there is a system that they're going to have to play around with to figure out what is the best coagulant and how to deal with the sludge if there is additional sludge. That will happen in phase 2. As we showed on the slide, the discharge does consistently comply with nutrient limits with some little blips. And the treatment plant was not specifically designed for phosphorus removal, and compliance with the total phosphorus is difficult because it wasn't originally designed. So there are some measures that they still need to work on. Again, this is year 5 of a 20-year temporary standard. So there are things that they are planning to do. Since the approval in January of 2020, the city of Raton purchased blowers and dissolved oxygen probes and installed them in their sequential batch reactor basins. Those provide BOD removal, biological oxygen demand, nitrification and denitrification to help with nutrient removal. Phosphorus removal is largely incidental and happens in all activated sludge processes to some extent. However, the city has updated their instrument plant programming and their on-off cycles to optimize nitrogen concentrations in the effluent. Raton issued a request for proposal for an engineering firm to conduct a zero discharge feasibility study. So they're also looking into potentially not discharging at the end of this temporary standard. So they're looking into that. They issued the RFP and they've done some pilot testing for phosphorus removal. That engineering contract expired and the city issued a new RFP in this month, May of 2025. And they're planning to continue the zero discharge feasibility study and the phosphorus removal coagulation study to figure out what will work best for their system. The city is continuing to pursue funding. They applied for Federal Congressional Water Resources Development Act of 2022. It was not awarded. So they went back and applied for FY24 rural development funding. Again, was not awarded. They applied for rural infrastructure program, solid waste collection truck through the Clean Water State Revolving Fund. That was approved. And Raton was last awarded Clean Water State Revolving Fund funding in 2004 for wastewater treatment plant improvements. The associated debt with that loan has been paid in full, and the Clean Water State Revolving Fund and NMED's program has stated that they would be happy to work with Raton to help them improve their wastewater treatment system. So I imagine they'll be applying for a revolving fund loan soon. They've started their permit renewal application, which is due to EPA Region 6 by July 31st. And the primary task associated with that permit renewal is analytical laboratory results for a pollutant screen. They've collected all of the samples needed. They're waiting for the analytical results from the contract labs. So they're making progress on this implementation schedule. Moving to phase 2, that will start in 2030. Phase 2 involves aeration control upgrades for nitrogen removal. Again, going to that state revolving fund funding, hopefully will help with those aeration control upgrades and refinement of the chemical addition for phosphorus removal. Implementation of the temporary standard and associated tasks requires both capital and operational expenses from the city's utilities budget. The 20-year phased approach allows the city time to plan and distribute budgets and fees and expenditures to lessen the impact to the city's utility budget, and promotes community support to encourage success of the temporary standard. So NMED concludes that progress has been made by the city of Raton, and nutrient concentrations are either decreasing or meeting the limits with occasional exceedances, but they're not at the levels required of the temporary standard yet. So they still have progress that needs to be made. They're not yet achieving that highest attainable condition. So NMED does not recommend revoking this temporary standard or additional conditions to the temporary standard for the city of Raton. We recommend keeping it as is, letting Raton work through the process. And again, we will be reevaluating, if not sooner, in 5 years. So if the commission approves no changes or changes with the proposed actions that Raton had, NMED will submit the reevaluation of the temporary standard to EPA. And if the commission approves changes or additional conditions or revokes the temporary standard, NMED will incorporate those changes into the upcoming triennial review process. And with that, I will open it up for any questions that you may have.
Thank you, Ms. Lemon. Questions? Commissioner Brinkard.
Okay, I'm sorry, Ms. Lemon, I got confused. What is the department's recommendation?
Mr. Chair, Commissioner, the department is recommending to keep the temporary standard as is.
What about these changes to the plans, et cetera, that are mentioned here?
So the two changes that Raton had requested, and maybe I can go back to my slides. Just a minute, I'll show the slide. So in phase 1, the two things that have changed is in the third line or bar under NPDES permit application renewal in January 2025 through January 2029. Moving pilot testing of coagulation continued. That's new from the original timeline. So this area right here, pilot testing, that was that was originally in the first 5 years, but they needed more time for that pilot testing. And also the funding was in the first 5 years, but as I mentioned, their funding, they attempted 2 different funding opportunities that they were not selected. And so it's taking longer for that funding to be achieved. So this table is in the Bureau's report that is referenced in the temporary standards. So we could update the report without a regulatory issue, because it says in the temporary standard at the bottom, number 11, the tasks and target completion dates are listed in the most recent WQCC approved version of the New Mexico Environment Department Surface Water Quality Bureau's Nutrient Temporary Standards document. So we could update that with the pilot testing and funding applications in the next 5-year period, like continued.
Okay. Does the department recommend that the commission approve those changes?
I recommend that.
Well, all we need to do then is to recommend that you change this document here that's referenced in the regulation to update it with the changes that you have just discussed.
Mr. Chair and Commissioner, yes, that's correct.
Thank you.
Any other questions? I have two. First of all, their NPDES permit expires in 2026. Is that correct?
Mr. Chair, it expires January 31st, 2026.
Okay. And so they'll need to apply
In July.
July of this year.
Mm-hmm.
Okay. How far behind is EPA on issuing permits? I believe the stormwater permit that AMAFCA, the stormwater agency that I'm a member of, expired in 2019.
Mr. Chair, EPA has some backlog, but they are addressing the backlog. They're trying to get the backlog resolved. And so I think currently there are 6 permits that are out for public comment for this month. And so they're decreasing that backlog load. For this type of permit, I don't anticipating it being administratively continued unless we have to change the temporary standard through a rulemaking. And then they would administratively extend the permit until we get the rules in place for them to issue a new permit.
Okay, so I think you just answered my follow-up question is, if the old permit is just administratively continued, any changes we make today would remain in effect.
Mr. Chair, if the NPDES permit is administratively continued, it's those effluent limitations and requirements remain in effect until a permit is reissued.
Okay. Or the other case when it could be evaluated would be during the triennial review.
Mr. Chair, that's correct.
And that will be next year?
Yes. Mr. Chair, if the commission is recommending changes to this temporary standard, we need to be directed at what those changes are so we can put that into our triennial review petition. So we would need to know what the commission wanted changed so we could make sure to incorporate it and support it in the triennial review process.
So any changes we make today would just continue through the triennial review process? We wouldn't have to come back and review this a second time next year?
Mr. Chair, if you're, there's two different changes we're talking about. One change does not require rulemaking because it's changes to the document that's referenced in paragraph 11 at the bottom of this. We can make changes to that document, like I mentioned, for the timeline of actions and target completion dates. We can make changes to that and have an updated version of the document that's referenced. If you're changing anything, any of the highest, you want us to change the highest attainable condition, change the term of the temporary standard to be shorter than 20 years, you know, those things would require a rulemaking to change what is listed in this temporary standard.
Okay, thank you. Years ago, I did some work with the city of Raton, and my recollection was Doggett Creek is an effluent dominated stream. I don't think I have a question. Thank you. Okay. What's the pleasure of the commission? We want to, NMAC has requested that we continue this, the temporary criteria with those two small changes. Commissioner Brancard.
Okay, I'll move that the commission continue the temporary standards set forth in 20.6.4.318 with the changes recommended by the Environment Department to the document listed in 20.64.318 C11.
I'll second.
Commissioner Molander.
I was just getting ready to second and I got beat to the punch.
Okay. I'm sitting up here, I'm watching I'm not watching your faces, I'm watching your hands, watching people to unmute their microphones. Is there further discussion? We ready to vote? Ms. Jones, would you please call the roll?
Okay, sure. I'm going to let Mr. Lopez take the vote.
All right, Commissioner Barunda.
Yes.
Thank you. Commissioner Brancard.
Yes.
Commissioner Fry.
Yes.
Commissioner Laney.
Yes.
Ms. Slinger.
Yes.
Commissioner Mowander.
Yes.
Chair Thompson.
Yes.
Commissioner Bayless.
Yes.
Commissioner Vihil.
Yes.
And Vice Chair Zemlik.
Yes.
Motion passes, Mr. Chair.
Okay. Thank you very much. All right, let's move on. The next agenda item pertains to, this is agenda item number 9. No, I guess it's number 8. It pertains to WQCC 23-84R, which is the wastewater reuse rule. We've got, I guess, 3 issues to consider.
Mr. Chair, you have 3 motions. There were some responses, a joint response to at least one of the motion and a reply to that response that was filed just today. So, yeah.
Okay. Thank you.
But there wasn't time for a proper briefing schedule.
Correct. Let me ask, for those who haven't sat through the previous proceedings on this, Ms. Orth was the hearing officer. So my question is, do you want to take over the meeting at this point, or do you want to leave me in charge? That's a mistake.
Oh, if the commission is willing to hear some oral argument on these motions, I'm certainly happy to call on the parties in a sensible order.
Know someone on the committee, like what the questions are.
I'm sorry, who?
I think that was unmuted.
And Mr. Chair, I wanted to address something quick. So I was not involved in this actual rulemaking. I have given a noble effort to get caught up on all the pleadings, transcripts, etc. I did not make it through all of them. And so I have a concern about me voting on this case. I also have a fear. I'm not sure whether or not we'd have quorum if I abstained from voting on that. But from an ethical perspective, I don't think in good conscience that I could participate in that. And I'm not trying to seek a way out of making a decision, but I do not feel informed enough on this because this was a massive undertaking and I poked my head in over the course of months, but I do not have a handle on the material. So I wanted to put that out there that I would almost certainly be abstaining and probably even on the motions because there's a lot of background that forms that I do not have a firm grip on. So I'm letting you know, Mr. Chair and Madam Hearing Officer, that that's where I'm sitting procedurally.
So, Mr. Chair, we have at least one commissioner on the platform. I believe you need 8 for a quorum. You might ask Commissioner Barunda if he's had a chance to come up to speed in order to deliberate with you.
Commissioner Barunda?
Yes.
So the question is,
yes, sir.
Yeah.
Mr. Chair. Yeah, I feel comfortable enough. I've been doing, of course, got up to speed. And even in this case, I'm very familiar with what we're about to discuss. Cross paths with this many times. So yeah, I'm good to, if you need, or of course not need, but I'm good to vote and discuss.
Okay, and Mr. Chair, I do not see a representative from NMAC sitting as commissioner, but that would mean you would still have at least 8 in the event Mr. Moanders abstained. Oh, Commissioner.
I would also have to abstain, I think, because I have not been able to get through everything.
Okay, so let's take another count. We have Commissioner Laney, Commissioner Fry, Commissioner Zemlich, Mr. Chair, Commissioner Bayless, Commissioner Brankard, Commissioner Vigil, and Commissioner Barunda. Right there on the edge.
yes. So there's, as I see it, help me out, Council. There are 2 issues. One is, do we have a quorum? There are 14, my understanding is there are 14 positions on the Water Quality Control Commission and that a quorum requires 8 people to be present.
That's correct.
Now, the second question is that it's my understanding, Commissioner Brankard has pointed this out, is that in order for us to take action, a motion has to be voted on by 6 people. It doesn't have to be voted on by the full board. Commissioner Brankard.
What the Water Quality Act requires.
Okay. Yeah.
Correct.
All right. So I just wanted to get that out on the table because we're kind of right on the margins.
Just to confirm, we can 8.
plus Commissioner. So I think we're good there. All right, so we have got three motions to consider. I think maybe the first thing is we officially closed the record at the end of our public hearing in August. And so do we want to consider these motions that have been submitted? If you're looking at the agenda, there is the joint notice and request to prevent plain error, a Wild Earth Guardians motion to clarify hazardous waste regulations, and Amigos Bravos, and Sierra Club motion for reconsideration from commission deliberations. So I think the first question, and commissioners, feel free to help me out on this. Do we want to accept, do we want to hear these three motions? Or do we simply want to go to consideration of the red line document, the revisions to the proposed wastewater rule that we enacted last month in April?
Chair, Commission, I have a question.
Please.
Okay, how about tabling items? Is there room for that, or is there, I guess, so that way others can get brought up to speed? Is there tabling? Is that an option?
Council?
I think really, maybe, I'm not sure how that would work, given the context.
Right.
So,
Yeah.
just so we're clear, I mean, the motions are relevant to the final deliberations and voting on the document.
That's
so
right.
If we table them, then we're essentially saying they're moot.
Right. So Commissioner Byrne, they got through the bulk of their deliberations, made a number of made many decisions, some of them smaller, some of them quite significant, and did not at the very end adopt everything they had done in any kind of final motion, because they wanted to see what the changes they made to the proposed draft had done. So that's why I produced that red line with the red ink edits. And they also wanted to see a draft statement of reasons. And then they were going to wrap things up now. And it's pretty important that they wrap things up today and or tomorrow, because the deadline is May 24th for their decision.
Madam Hearing Officer, would you explain that to the public, the deadline?
Oh, yes. The commission has 60 days following the close of the record, and the record is considered closed once they have the hearing officer report in hand. And for better or worse, my hearing officer report came in on March 24th. So 60 days was May 24th. That's my memory of the dates.
Okay. So I think there's a little bit of pressure for the commission to take action today or during this proceeding today or tomorrow if we have to go into a second day.
Chairman, Commissioners?
We're not taking comments from the public at present. Oh, I'm sorry. It was Commissioner Barunda. I didn't see who was speaking.
So I'd like to say thank you. Yeah, that clears up the question of if this item could be tabled, because this sounds like we're on a deadline. So yeah, some sort of action has to be taken in this meeting then, or like I said, tomorrow.
Commissioner Brancard.
Okay, well, let me get the discussion going here initially on these motions. I mean, I think if the commissioners think that it would be helpful to hear from the parties discuss these issues, that's fine. My personal feeling is that these issues are big picture issues that have been raised, important issues that I think we will continue to address as we finalize these rules. While it's good to have a reminder of them, it's not necessary to have an oral argument or a decision made on these motions. These are simply issues that we need to discuss amongst ourselves as we reach a final decision. And I think it's helpful in some ways for these motions because it sort of maybe forces us to step back and look at these bigger picture issues rather than simply going back line by line through proposal, which is what we did last time. So that's my feeling. I don't see a need for oral arguments on this, but if other commissioners think it'll be helpful for them to hear from the parties, I will disagree with that.
And Commissioner Brancard, I had only suggested that the agenda include oral argument because there was not time for, if you will, a proper briefing schedule. That was why I suggested it for the agenda. But it's definitely up to the commission in terms of whether they would find that helpful or not.
Works for me. Okay, so you want to go through these one by one? Commissioner Brancard, is that your suggestion? Oh, I'm sorry, I misunderstood then.
He said he didn't feel the need to hear all.
I thought he was just referring to oral arguments.
Mr. Chair, you can structure the discussion for the rest of the day however you'd like. You want to talk about the big issues first or dive back into the rule line by line?
I'm looking for a recommendation from one of the commissioners. Any of the commissioners. Commissioner Laney.
I'm afraid I can't help with recommendation. So I was hoping that maybe we could get some guidance from our legal counsel on some of these motions if we're not going to go through each one of them one by one, because there were some of them I got a little bit confused on as they seemed like they were based off of some sort of speculative narrative that was going on that I didn't know was going on. That's all. That doesn't help with the ordering things out, just that I would like to hear an interpretation of what some of these motions are. And I can start with the first one that comes off is the Amigos Bravos and Sierra Club's motion for disqualification. If you guys could kind of digest that into a quick synopsis for us. No,
that one's easy. It's not relevant today.
Thank you.
Yeah, for the benefit of the audience, that motion that Commissioner Laney's referring to, we thought that Secretary Kenny, Secretary of the Environment Department, was going to sit on the commission today, and there was a motion to disqualify him. He had several other commitments and is not joining us. So that motion is moot.
So just to clarify, the Maxwell response in opposition of Amigos Bravos would also be moot at this point.
Yes.
Thank you.
Yeah.
Just so we're clear, the ones that Hearing Officer Orth is referring to are the three that were submitted before yesterday.
Thank you. I did need that clarification.
Mr. Chairman, are there any issues that you'd like to see the commission address before we dive into the details?
Yes, I suppose the one motion that gave me the most concern was the motion submitted by New Energy Economy Wild Earth Guardians and their collaborators, joint notice and request to prevent plain error. And this is a motion that, as I understand it, refers to the Produce Water Act, which specifically requires that a permit be issued for reuse of produce water. And we last month did not require a permit process. We allowed reuse of treated produce water from a pilot treatment plant based simply on a notice of intent. So that was the motion that gave me the greatest concern. I thought that was a pretty important point. And I don't personally know how to respond to that. Commissioner Brancard.
Well, I can try to respond. I think the Environment Department's position, because I raised this issue during the hearing about the permit requirement in the Produced Water Act. And I believe their position was that the Produced Water Act is essentially sort of subordinate to the Water Quality Act. And that what we're talking about here is Water Quality Act permitting, the discharge permits that are specifically authorized by the Water Quality Act, and that produced water permits as such have to be discharge permits under the Water Quality Act. And therefore, if you don't have a discharge, you don't need a permit. Okay, which is the way the Water Quality Act evolves. And in fact, they're mimicking a process under our regulations that says that if you're not sure, you file a notice of intent and the Environment Department determines, do you really have a discharge? And if you don't, thank you very much. Go ahead and do whatever you need to do. The process that they have created in the rule is more elaborate than the process that's in the rest of the water quality regs. And based on all the changes we made to it, it's even more elaborate now. In fact, one could argue it's almost starting to look more like a permit. But that's the reality. And I guess I've been disappointed in the filings of the Environment Department, both post-hearing and the lack of responses to these motions, that the Environment Department has not really stood up for that position or stated why they agree with that, or why the permit provision in the Produced Water Act is not a problem. So, okay, let me get on my legal high horse here. We're interpreting a statute, actually a piece of legislation, House Bill 546, which contains several statements about jurisdiction, right? And two of them are statements about the Water Quality Act, and one is in what's now called the Produced Water Act. Okay, all dealing with produced water. I think, you know, the goal, as the courts have pointed out, and there was a very recent decision the last month from the Court of Appeals that dealt with the Ethics Commission, went back over this whole territory once again, that you have to look at all these provisions and look at them together as a harmonious whole. I always screw that up. That's where you're all supposed to hum. And so that's sort of the challenge we face, is to look at these provisions and sort of make them work together somehow. And I think that's what we're faced with here. And I guess I disagree with the Environment Department's interpretation, because I think the legislature has created duties for this commission and for the Environment Department specifically that go beyond sort of just adding something to the Water Quality Act. That they're asking us to regulate not just the discharge of produced water, but the treatment, storage, disposal, etc. of produced water. And again, looking at the statute, there is a similar amendment to the Oil and Gas Act in House Bill 546, in which the language is almost identical, in giving the duties to the Oil Conservation Commission, that they have to regulate the treatment, storage, transportation, disposal of produced water. And in fact, that language sort of predates House Bill 546 because the Oil Conservation Commission has been doing that for years. And they have a whole series of rules on storage facilities, recycling facilities, transportation, injection well permits, etc. And so I think this is a sort of a bigger task in some ways than what maybe the Environment Department is thinking it is, at least judging from this rule. I guess I sort of share a concern with the chair about the direction that we're going here with this proposal. I'd be curious if our council had any thoughts about interpreting the statute.
If it's okay, I'll wait until we get more input from the commissioner.
I would be interested in what the hearing officer has to say, because I know she considered this in her report. So
I think one of the issues here is that at the moment, what you deliberated on and what reflects your first days of deliberations allows for discharge for a pilot project. The proposed rule, by the time we got to hearing, did not propose allowance for any discharge whatsoever. It was all closed loop. And I thought the Bureau made sense when the testimony they gave was, we're going to determine that there is no discharge, which means there's no discharge permit required. So the commission moved from the proposed closed loop, no discharge, and therefore kind of sensible argument that no discharge permit would be required, to allowing discharge up to what was 80,000 gallons a day in a pilot project without necessarily maybe bringing all of the discharge permit process with you. That's my impression of how we're here.
I have some, thank you, Chair Thompson. Yes, I agree with that. And I reflected on it a little bit after the hearing because, you know, it was just us discussing it without being able to ask questions. And I think some of the confusion was when we were having the hearing itself, there was a lot of confusion about the terms that were included in the original rule. So we had industrial, we had pilot, demonstration project, and I remember kind of it kept coming up. We need from the public as well. How do we know there's going to be a closed loop facility that isn't enormous, you know, that's advertised with an NOI that pops up? And I think part of the arrival at a discharge permit may have originally started there and maybe shouldn't have ended up where it did. Because all of the evidence that we saw had to do with the NMED NOI facilities that are currently permitted. I think that's perhaps where that 2,000 barrel per day number came from. That might provide a bounding in terms of capacity on deployment of these types of facilities. But that extra step of a discharge permit was getting the cart before the horse, which was the NOI process and the data collection in the closed loop before having standards that the department has proposed.
what after I received this motion from New Energy Economy et al., I went back and reread the Produce Water Act, which I hadn't looked at in 6 or 8 months. And one of the things that concerned me was the Produce Water Act specifically refers to a permit to let's see if I can find it, a permit to reuse the water. And we're trying to, that's what's required in the act. We're trying to make groundwater discharge permits fill that purpose. And I think it's a stretch, particularly if you want to reuse it other than for application to land. So for instance, if you wanted to use it for industrial use, cooling water, you wanted to use it to make cement, you wanted to use it for generating green hydrogen. Those would not be subject. It's not clear to me that those would be subject to a groundwater discharge permit. So again, I'm seeing the same congruity between what I see in the act and the groundwater discharge permit that's specified in the original draft, in which we subsequently changed to just allow an NOI submitted to the Groundwater Quality Bureau. So I'm rambling. I'm not sure that's leading us anywhere, but that's where some of my confusion is. Commissioner.
No, Mr. Chairman, I completely agree, because that's part of the reason why I introduced the request to eliminate the industrial projects, because that seemed to be the clear conflict there between the words of the Produced Water Act and the discharge permit requirement of the Water Quality Act. Whereas you can create a whole use of produced water, such as in a closed loop industrial project for cooling water, where produced water never touches the ground. Therefore, there's no discharge to be regulated under the Water Quality Act. Okay. But to my mind, that's clearly a use of produced water that should be regulated from the Produced Water Act side. If we take that command seriously from the Produced Water Act. And so I thought that was a real conflict there. I think it gets harder when you get to these experimental projects, you know. I mean, can you carve out sort of a de minimis non-use from the permit requirement? I don't know. At first I thought maybe, but maybe I'm sort of leaning against it now, you know.
Again, I'm going to continue to ramble. It seems to me, based on the testimony we received, that there is a real need to expand the magnitude of the pilot testing that has been done to date to a larger scale. Most of the testimony we received on pilot testing was done in the lab, bench scale. There was some testimony given on pilot testing that was done, I think, in Texas. Not much, but in order to develop the technology, it needs to go to a bigger scale, bigger flow rates. And so I support that. I support the idea of expanding the testing. The problem is, if you go to a scale of hundreds or thousands of barrels per day, how do you get rid of that water? You can't really reuse it within the industry. They don't need that volume of water. So I support the idea of allowing reuse of pilot treated water at a reasonable scale. But again, as I said earlier, the groundwater discharge permit process doesn't quite cover that very well, unless you're going to use it for land application.
Chair Thompson, I've said this a couple of times, and I would just reiterate, is that I do, as Commissioner Brankert said, the Oil Conservation Commission rules are there, allowing for various reuses of produced water. I think they have the mechanism in place for something that's larger than what would be considered a pilot project. And I also think it's important to keep in mind that, you know, this is an evolving process, and a big part of trying to, I think, engage in this rulemaking is to have a more robust data set upon which to make decisions. And so I think there's a couple of different pathways now. If pilot projects without the ability to get a groundwater discharge permit could happen off of the oil and gas field, that's an additional mechanism to what they have now. And the existing NOIs that NMED presented, I think, I don't know, I'll estimate 75% of them were at current recycling facilities.
For my benefit, when you're talking about recycling, you're simply talking about reuse for fracking.
Yes, those facilities were permitted for produced water recycling facilities for use in oil and gas.
So they are not recycling the water for use outside of the industry.
Yes. But that does not mean that they could not conduct those types of tests at those facilities, produce data at a large enough scale that would then be persuasive enough to deploy it elsewhere if pilot scale projects were not sufficient.
So I understand you're suggesting that they could use the treated produced water from a pilot scale, from a large scale pilot plant. They could reuse that water for development in place of untreated produced water for fracking. Transportation. Commissioner Laney.
Yes, I'm sorry. I'm inexperienced with the correct formality here, so I apologize in advance, but it seems like we all have some discussion around what we redlined and what was put together, and I'm not quite sure what is the appropriate way for us to go about looking through that, discussing the things that are giving us heartburn or whatever it may be giving us. I don't know the formal process to do that. I'm sorry, I'm naive in this a little bit still, so I could use some guidance there, but I think it would be worth our time to go back through our document, look at what we redlined, and discuss the things that are irritants to us.
I think that's agenda item 9. And so once we dispose of 8, I think that's what we would be doing 9 in the commission.
Can I
Yes.
ask here, something the hearing officer had said? I thought her suggestion was we didn't have to go exactly in order of, well, I guess if we want to hear oral argument, then we need to go through that. But if we're just going to discuss it, then we can just go into deliberation and wrap that into that. Am I misunderstanding?
I'm sorry, would you repeat the question?
I had understood from an earlier comment that if we're having oral argument, we should go through that now. If we're not having oral argument, we can go into deliberation and just wrap the discussion of these 3 notices into that discussion.
I believe that's correct. I would defer to Mr. Agarte on that, but if you're going to hear the motions or take action on the motions, I really think that would precede the resumption of deliberations.
Right, I agree.
So we need to decide if we want to hear oral argument.
Yes.
I'm sorry, I was distracted.
Mr. Chair, you're going to decide whether to hear oral argument on these motions or take other action on these motions with or without argument before you actually resume deliberations.
Okay, what's the pleasure of the commission? We want to hear or arguments on this? Not hearing anything. I'm not inclined to hear oral arguments. I think we've got the document, we've got the motion, pretty clear. Commissioner Brancard.
Mr. Chairman, if you want a motion, I can move that we not hear oral arguments and go directly into deliberations.
A second.
We should say our names more frequently, probably. This was Commissioner Zemlich. Yeah.
Okay, is there discussion of the motion? Mr. Would you call?
Okay, vote on the motion. Commissioner Barunda,
Yes.
Commissioner Brinkard,
Yes.
Commissioner Fry,
Yes.
Commissioner Laney,
Yes.
Commissioner Langer,
Abstain.
Commissioner Melander,
Yes.
Chair Thompson,
Yes.
Commissioner Bayless,
Yes.
Commissioner Vihil,
Yes.
and Vice Chair Zemlich.
Yes.
Motion passes, Mr. Chair.
I just want to clarify, Commissioner Brancard, your motion dealt with all three of the requests?
Yes, that was my understanding of my own motion.
That was my understanding as well. I just wanted to clarify. So if that is the case, that what we're going to do now, I think, is go directly to agenda item 9, which is deliberation on the proposed rule, WQCC 23-84. And that would be the red line markup that tried to account for all the suggestions and changes we made last month.
Chair Thompson, if I may just briefly, I did invite the parties to identify any place I might not have accurately reflected what the commission decided in the last meeting. And Select Water Services with NMAC's agreement found 4 relatively minor, but still need to be addressed changes. And I did pass out a hard copy of those 4 changes. One is the word discharge in the definition of treatment. One is the word distributed. I had changed demonstration to pilot 100 times, but it turns out there were 101. And the deletion of a reference to part 1201 in the discharge permit rules. But you should have a piece of paper with those 4 changes in front of you.
Okay.
And I have a question for the Madam Hearing Officer, if I may. So I just pulled up the red line and I hadn't noticed this before. There's some phrases underlined in black and some strike throughs in black. Are those from us or something else?
So I took the final proposed rule in Exhibit 175, and I think it was you actually who requested that when I prepare this document, I make a distinction between the proposed edits in Exhibit 175 versus the edits that the commission was making in its deliberations, and to show the commission's edits in red. So everything else was as proposed by the department.
Okay, thanks. I guess a month was a long time ago.
Okay, so what we're going to do is we're going to move on to agenda item number 9. But before we do that, it's 2:30. Let's take a 15-minute break and reconvene at 2:50. Okay. A little longer break than I expected, but calling the meeting back into session. We're on agenda item 9, which is deliberation of WQCC 23-84R. At our last meeting in April, we went through the proposed rule line by line and suggested changes. And as always happens with changes suggested by a large committee, they're confusing. And the hearing officer, Ms. Orth, has undertaken a heroic effort to try to capture all the changes that we suggested and harmonize and put them into the regulation. And that is has been submitted, and it's posted online under docketed matters as a red line strike through markup. And so I think at this point, we're going to go through that line by line again. And this is 20.6.8, ground and water protection, supplemental requirements for water reuse. And so I hope everyone has got either a copy pulled up or access to it. And then I'm going to turn this over to Ms. Orth, I think, if you do, because you were the one that made these changes. Are you comfortable doing that, or do you want me to run it?
I think it would be, I'm sorry. I think, I'm not sure where the commission wants to take the discussion. If you remember, there were 3 major questions. Do you want to rule it all?
Yes.
Right. Should the rule allow discharge, and is the NOI process sufficient? My report had all of the arguments from all directions on those major questions. And then attachment A to the report had the less major questions, if you will, with the arguments from each of the parties beneath each section. I guess I would invite any commissioner who has reflected on the red line to maybe offer whatever observations they have about that. Because I'm not sure going page by page is the right strategy, or if you want to revisit the major questions at this point, I'm not sure.
I think that's a good suggestion. Let us revisit the major questions. Recall, that's how we started our discussion last month. Ms. Orth posed 3 questions for us. And the first question was the overriding question: do we want a rule at all? Or I assume if we don't, we would ask the Environment Department to go back and craft something a little bit different, quite different. So just let's revisit that question right now. Are we comfortable with passing a rule on wastewater reuse? Commissioner Neal.
I was under the impression last month that we answered these 3 questions.
We did. I guess my question today is, do we want to revisit them based on a month of reflection and a markup that Ms. Orth has offered?
I would presume that I would propose that we just go through the red line markup myself.
Ms. Simlick.
Thank you, Chair Thompson. I think I would reassert that I think what we agreed on the last meeting was that we do want a rule, which is also suggested by the desire to go through the red line copy now. And that I think part of what we discussed earlier that we got twisted around was the second question about discharge. And I might propose that we address that substantive issue first, because I think maybe that will require the most discussion. And then after that, if we want to go line by line, that might be a better use of our time. And so do I have to make a motion?
No, I don't think we need a motion. Okay. Just asking for how the commission wants to proceed. Watching your finger commit.
He missed mine.
Oh, I thought that was the middle finger. Yes.
Not yet. This is Commissioner Fry. I guess I'm thinking if we went through the red line, it would help get our brains wrapped around this and help move the discussion.
I agree with Commissioner Zimlick. I think it would be a good place to start by reviewing the discharge aspect of this and kind of doing that by also going through the document here in front of us and really weighing that question against what we have documented in the rule. That's where I suggest we start in agreement with you on that. So line by line is fine. I don't know that we need to wind up in the same place that we were last time. I think we need to look at the question and then we can look at the line by line as well, but weigh the question against the rule that we have redlined.
Okay.
Thank you, Chair Thompson. I forgot to mention one other thing that is easy to forget is that this is about water reuse, not just produced water reuse. And so I think that's also guiding my assertion that I think we agree that there's a need for this. The sticking point just happens to be produced water reuse in the discharge section.
Yes.
Whatever the pattern of going through it, I'm fine with.
Okay, so the Katies have suggested that we start by discussing whether treated wastewater, and in this case, treated produced water, will be allowed a discharge of that. And that, I think, is in section 20.6.8.400. And specifically 20.6.8.400. A4. And so I'm sorry, 20.6.400. B. It says authorized, and I'll just read it. It says authorized pilot projects that involve treated produce water may be allowed under a discharge permit. Pilot projects determined by the department not to require a discharge permit are subject to the following requirements, and it references other aspects of the rule. Okay, so is everybody clear on where we are? Should there be this? Do we want to change that? Again, I'm dealing with 20.6.8.400, section B, authorized pilot projects. Commissioner Brankart.
Well, let me just throw this right out that despite all the great efforts that we had last month, maybe it was the aura of the room, I don't know. Perhaps I would suggest that we step back from that change, which, you know, in hindsight is a fairly dramatic change. I think the justification for allowing discharge permits is because the original proposal by the Environment Department did allow. But by the time we got to hearing, that was gone. And the second justification was the chair's idea that we limit the scope of these projects so that we wouldn't really be allowing massive pilot projects, discharge projects. But I think that, you know, the issue that was all along there, and the Environment Department emphasized that they really were not ready to handle discharge permits for produced water. I think that was their testimony. And that there are a whole series of issues that they would have to come up with on the fly for each permit, including, most importantly, how to characterize the produced water and what are the standards that you needed for the produced water, which they clearly indicated they were ways away from coming up with decisions on. So at this point, I believe it's premature for us to authorize discharge permits, even for pilot projects. And finally, there's the issue that we discussed a little bit ago, which is even the concept of the discharge permit the right tool for these produced water projects? Clearly, there has to be a permit, but perhaps it's something different than a discharge permit. Okay, the focus is on all of the activities surrounding the handling, storage, transportation, treatment, disposal of the produced water, not just the potential discharge of that produced water at a location. And so that's a bigger thing to come up with in a rule. Not that it's impossible. One idea I was going to mention earlier was that the Environment Department and this commission has done this already. Okay, a decade ago, the legislature told us you will come up with permits for the dairy industry and for the copper mining industry. And the result was lengthy, detailed rules governing permits for those industries. And so, you know, it's been done. It can be done. So I think that's more the model in some ways, perhaps even better than what maybe the OCD has done over decades, would be those. But anyway, so my proposal is to eliminate the language. It's in A4, it's in B, it's in C, about allowing discharge permits for pilot project. Throw that out for discussion, or I could make it a motion, or probably be good to have a discussion.
My mic was off. Let's discuss that first before we entertain a motion. I will say that I would support that type of a motion. I think that we've just kind of sort of gone sideways with the NOIs. Again, particularly in light of the reading of the plain language of the House Bill 546, the Produce Water Act. Other commissioners?
Are you proposing to eliminate the pilot projects entirely or just the discharge permit aspect of it?
Mr. Chairman, Commissioner, at this point, I'm just looking at the discharge permits for pilot projects, which is set forth at the beginning of B, 400B. Okay. Other commissioners?
Chairman, this is Commissioner Barunda.
Please go ahead.
Yeah, I agree. You know, especially if this is something like this has been done in the past. Why reinvent the wheel? Let's go with what we had utilized in the past.
Other comments? Commissioner Zemlich.
Thank you, Chair Thompson. I agree with what Commissioner Brankard has suggested about removing that language. The other part of that, which I think we should consider, is the pilot project size and whether that is something that NMED should decide, or we should strike that as well, because the 2,000 barrels per day. The reason that that I'm raising it is because during the course of our last hearing, I was looking at the existing projects and that seems reasonable, but there's not really a scientific reason that I've seen to make that suggestion. And I wonder if perhaps we should consider removing that number.
Okay, well, let's do these separate. I agree that the size of the pilot projects is a good topic for discussion, but I think the question before us right now is, or the suggestion that Commissioner Brankard has offered is that should we allow a discharge from pilot projects in which process is to treat produced water? Awkward sentence.
Chair and Commissioner, I was just going to chime in that during our last discussion, we spent some time also discussing the duration of this. And I just wanted to point it out. We have established a sunset on this particular rule of December 31st, 2030. So basically what we've done is this is the initial steps into understanding this discharge and this produced water better. So in 2030, this will have to come before the commission again to further deliberate if we're at a point where we move beyond a pilot project state and into a state, whatever that may be. I won't speculate. So I think that edging on the side of caution, it is perhaps in the best interest to not allow discharge as a pilot project, knowing that in 2030, we will reconsider everything that has been put into this, as well as hopefully see further definitions and expansion of this discharge rule.
Thank you. I think I expressed my concern last time that 2030 is an awful long ways in the future. It's if we do not allow pilot discharge from pilot projects, I think perhaps we should move that date up to allow the industry to opportunity to develop technologies, develop and demonstrate technology. Commissioner Zemlich.
Thank you, Chair Thompson. I think that's the deadline that we set, but the parties can bring it before us at any time before that.
Okay.
And I'm sorry to be interrupting. I think I'll be interrupting though when you're making especially a big decision. I definitely heard Commissioner Brankard offer reasons given by the Environment Department and others in support of this proposal. And I just want to make sure that I can, in redrafting the SOR, rely on the arguments made by the parties exhorting you not to allow discharges, the department, Amigos Bravo, Sierra Club, NEE, the frontline community members and Center for Biological Diversity, that I can include at least the essence of those arguments in a new draft statement of reasons. Yes? Okay, I see nodding heads. Thank you for letting me interrupt.
Thank you. Commissioner Brankard, I think we've discussed the issue. Are you prepared to make a motion?
Sure. I move that we amend the current draft of our proposed rule to in section 400A4, delete the opening phrase except as provided in subsection B. And then in section 400B, delete the first sentence, pilot projects that involve produced water may be allowed under discharge permit. And the other one I see is 400C1C. It says at the end, the department shall inform the applicant if a discharge permit is required. There may be other references.
I'm sorry, where's that last sentence?
It's 400C1C. The end of that paragraph. Paragraph begins based on the information. I'm not sure I got all the references to the discharge permit, but
There's B4, Chair Thompson, Commissioner Brankard, this is Commissioner Zemlich. I think it says issued a discharge permit or was added. And I think that could just be removed. So it would read, pilot project shall not commence until the department has made a determination of no permit required.
I concur. So my motion is to delete all references to issuing a discharge permit or pilot projects, and I've listed, I think we have listed what we think are those specific references, but we can go back through.
I will do that.
Okay. Motion has been made. Is there anyone willing to second? I will second it. I can do that. Can't I?
Yes.
Thank you.
Can we have discussion?
Absolutely.
So this is Commissioner Fry. So under, let's see here, I believe it was 400B, removing that first sentence. And then the second sentence says, as we changed it, pilot projects determined by the department not to require a discharge permit are subject to the following requirements. Do we leave it as required discharge permit, or do we simply say required discharge? Because I think that's how they originally had it.
I'm sorry. Where are you again, Commissioner?
So on 400B, second sentence, or at least the one, it'll be first sentence once we delete the first one. Originally, the language was such, it said, because the demonstration project or industrial project will not discharge in a manner that may directly or indirectly affect ground or surface water. And we changed that to say pilot projects determined by the department not to require discharge permit are subject to the following requirement. And I'm asking if we should change that to determined by the department not to require discharge.
I think you might want to restore the language that's been deleted there as an alternative, merely because that was the basis for the Groundwater Bureau's proposal, if you will, to allow projects without a discharge permit, because they will have made that determination. And that language comes from, I don't remember, 20.6.2, I think.
So shall I read what I think you're saying?
Okay.
So we're striking the first sentence and we're saying pilot projects determined by the department not to require a discharge permit because the demonstration project, or with our changes, the pilot project will not discharge in a manner that may directly or indirectly affect ground or surface water, are subject to the following requirements.
That is what I was describing.
Okay, with that change, I'm happy to vote.
I accept that amendment.
And I accept it as well. Further discussion? Is everybody clear what we're voting on? We're striking the first sentence of B, which refers to authorized pilot projects. First sentence says pilot projects that involve treated produced water may be allowed under a discharge permit. So we're disallowing discharge from pilot projects. And then there's a couple of other references to pilot projects. Also in A4. And in B4, subparagraph 4, and in C. And the hearing officer has promised she'll make it clear and consistent.
I will, sir.
Thank you. Are we ready to vote? I'm seeing heads nod. Please call the roll.
Okay. Vote on Mr. Brinkhart's motion. Commissioner Barunda, how do you vote?
Yes.
Commissioner Brinkhart?
Yes.
Commissioner Fry?
Yes.
Commissioner Laney?
Yes.
Commissioner Langer?
Abstain.
Oh. Okay. Thank you. Commissioner Melander?
Abstain.
Okay, thank you. Chair Thompson?
Yes.
Commissioner Bayless,
Yes.
Commissioner Hill,
Yes.
Vice Chair Zemlik.
Yes.
Motion passes.
Okay. So it's rather momentous. We're
I don't think that's, I think Eduardo would advise you not to. Oh. Sorry, Mr. Conte. Should the chair entertain commentary from council?
from one of the attorneys. No, I don't think so. Not at this point. Okay. So what's the pleasure of the commission now? You want to go back through the draft line by line? Commissioner Laney, you had a suggestion earlier. Where we were talking about revisiting the sunset date.
No suggestion to revisit the sunset date on my part, just a reminder that we had established one. It may be something the commission wants to revisit, but I think what that provides is a known revisit date. And that's all I was emphasizing there. There's nothing that would stop the Environment Department or others from bringing this back to the commission before that date, but it does prompt that by that date, it must be gone back through.
Okay. Yes.
And if I can kind of recap my understanding of what you're saying, it was because we have that date that allows us, the NMED, to have time to work out the details that they're missing right now. And so we have a date when we can readdress this. Is that?
Okay. Hearing no other suggestions, let's quickly go through it. I'm sorry. Commissioner Rankard.
All right, well, let me bring up the really ugly issue, which is, do we think that the process for approving pilot projects in a less than a discharge permit scenario is adequate to comply with the statutory requirements? In other words, Produced Water Act says permit for uses. Is this a use that requires a permit? Is this process a permit? I think we've kind of danced around this all along here. And so maybe we should just throw it out there and see what there is. I think we're sort of averse to forcing the issue in some ways, because the result could be that we end up with nothing. But I think it needs to be dealt with. Certainly the parties have put us on notice about this issue.
Thoughts? So as I understand what we've just done is we are not allowing any type of reuse from pilot projects. Is that correct? Let me clarify. Any type of reuse outside of the oil and gas industry.
Mr. Chair, I think the only thing we just disallowed was discharge. Reuse is still authorized under these small pilot projects that don't involve a discharge under the current draft.
Okay. So they could reuse this, for example, for industrial use, such as cooling tower, outside of the industry.
We're still talking pilot projects.
Yes.
Okay, so these are still experimental projects. Where they are greenhouse projects, whatever you want to call them. You're just not putting the produced water on the ground or allowing it potentially to come in contact with groundwater, surface water, right? So it's smaller scale projects under certain controls. That's what these notice of intent projects were originally envisioned, I believe, by proponents here. And so do we want to continue that? In order to continue with that, I think we have to address the issue, is that a use that requires a permit? And if yes, is this a permit?
Yes. Okay, so to make sure that I understand, what we're looking at now is section 400 part C, which on my red line markup is on page 12. It says produced water notice of intent. And I think Commissioner Brancard is dealing with this question that we raised earlier, that the Produced Water Act requires a permit to reuse the water. And if, correct me if I'm wrong, but the issue is notice of intent is not a permit. Should there be language in this wastewater reuse rule that establishes a permit for reuse of produced water, even from a pilot plant? Is that accurate?
Right. If we think this is a use under the Produced Water Act, then it would need a permit. Question is, can we refashion this into a permit? Now, the argument made by some of the parties is that it's kind of this sort of flipping back and forth between the Produced Water Act and the Water Quality Act, right? Where the Produced Water Act is the one that says a permit is required, but then the parties flip over to the Water Quality Act and say, oh, you have to now follow all the procedures for a discharge permit in the water quality. Okay. I mean, I think at first I was sort of not at all in agreement with that, but the more I looked at it, I wonder whether that may be the only choice.
Yeah. Commissioner Langer.
I have a question. I don't have it here in front of me, but what are the defined uses in the Produced Water Act so that we can gauge this a little bit better?
Okay, so the language in the Produced Water Act says, for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, person shall obtain a permit. Okay, so now you have to go back to the Water Quality Act, right? Which says that the commission shall adopt regulations for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water. And it lists a number of examples.
Yes.
Then I think they say uses regulated by the Water Quality Act, I think that phrase then that's in the Water Quality Act governs what those are, or helps define what the uses are.
Can I?
Yes, please.
This is Commissioner Fry. So, Commissioner Brankert, are you then proposing that Section C become produced water permit?
That is one way to do that. I mean, I guess I'm, in the one way, it seems easy to me, but I guess that's my background. You know, Commissioner Moander can second this, coming from the OCD background where we have permits of all shapes and sizes. But I'm also wondering whether we're going, you know, and I'll ask the hearing officer and commission counsel, how much changes can we make to this draft without it become something different? Thanks. So that's my concern. I obviously have made lots of changes in our discussion earlier, but you know, how many changes can we make before it becomes something different than was proposed to the public?
So I again would defer to Mr. Ugarte. My understanding is there's some relatively recent case in which some appellate court in New Mexico said no more logical outgrowth or something, that wasn't a meaningful term anymore. Having said that, I think with the iterations that the proposed rule that the department made, and with the rules as proposed, for example, by some of the other parties, right? We had at least a couple of parties say it requires a discharge permit. I think anyone participating in this proceeding, or even desiring to participate in this proceeding, was on notice that this commission would be deliberating on the question of notices of intent versus discharge permits. So I'm not troubled by it. I think there's a more logistical consideration, which is doing something other than referring to 20.6.2, where we all know what a discharge permit application and process looks like, coming up with a completely different discharge permit process out of whole cloth while you're sitting here, if it hasn't been proposed by a party, is going to be a real challenge. But that's my concern, Mr. Ugarte.
I would just mention there's a little sleeper provision in this rule, in section 100, which says, unless otherwise required by this part, all persons are subject to the state's ground and surface water protection regulations at 20.6.2. Okay, so those are the regulations that the hearing officer was just referring to, which has the process for public notice, comments, hearings, etc., on a permit application.
And y'all did insert something there, sort of a, you know, at least a halfway measure, that new subsection 12, about documentation that all property owners adjacent to the property or properties in which the demonstration project, that would be pilot project, will be located, receive actual notice of the application for a notice of intent, and how to obtain additional information regarding the project. So you did take at least one step, if you will, to add something to a notice of intent project process that you know, is certainly of interest to people when it comes to the discharge permit process. But okay, I'm sorry, Mr. Ugarte.
So my understanding is that the original rule, when that was presented, included a discharge permit. So I don't think what I've heard so far is going beyond that. The other thing to just keep in mind for the commission is that whatever you decide has to be based on the evidence that was presented, that will go into your statement of reasoning. And so as long as that just limits what you decide on, what you can't be arbitrary with what something you came up with. So as long as it's based on the evidence that was presented, then it's fine. Is that helpful?
Chair Thompson. I don't have especially the way we've changed the notice of intent section. I'm fairly satisfied with that. If we felt a need to have a permit or call this a permit, I would not want discharge permit. I would not want that name because we've already said we're not going to allow discharge. I guess that's my 2 cents.
Commissioner.
Yes, Commissioner Laney. So I was looking at the closing arguments that NMAC made, and they acknowledged that although the Produced Water Act states that a permit for the Environment Department must be obtained, that doesn't supersede or circumvent the Water Quality Act. So I'm not sure. So regardless, the Water Quality Act ensures that they have to have that discharge permit. NMAC seems to feel confident that this process would not exclude them or circumvent or eliminate them from having to go through what would normally be gone through. It seems that the wording is what is different. So the Produced Water Act says that it has to have a permit. The rule before us is used pilot project, which does not imply permit. And I see the concern that you're bringing up there. I don't know. I don't have a solution here for this conundrum, because pilot project, looking at it from a regulatory enforcement standpoint, has no enforcement capabilities. It's a pilot project and they either accept it or they deny it. If they find that the Water Quality Act would cover them in that case, but if they found that something was being done that they didn't agree with as part of that pilot project, what would stop that pilot project from occurring if they weren't discharging it? If they found they were storing it or holding it or recycling it in a way that is against the produced water rule, I'm concerned about whether or not there could be any regulatory consequence if somebody was not performing a pilot project the way that they should be performing a pilot project. So I see your point, and I don't know how to fix the language that they've put in here, because pilot project does not equal permit, which the Produced Water Act is saying needs to be part of it. I'm probably just complicating it, and for that I'm sorry, but I was looking through it, and you're right. It's not the same. It's not implying the same thing.
It seems like the intent of the discussion is to see if there's a way we can put a permit process fitted into section 400.c, which right now is listed as notice of intent. And what the NOI now lists in subsection 1 is the requirements in an application, but there's nothing in there that would go in a permit as I would envision it, which would be a duration, monitoring requirements, some type of perhaps a third-party review. So I think if we wanted to try and change or amend section 400 part C to create a permit process, it would require a lot more modification than I would feel comfortable doing today. Okay, Commissioner,
What are the repercussions if we just leave it as NOI?
what troubles me is the Produce Water Act requires a permit. And the way I understand the Produce Water Act, if someone wanted to do a pilot project and use that water for any purpose outside the oil and gas industry. The example I'm using is cooling water, but Commissioner Brankard also mentioned in a greenhouse. So it's closed loop. We're not losing control of it. It's not going to be a discharge to surface or groundwater. I don't think that would be allowed. That would require a permit, and I don't think an NOI constitutes a permit. Commissioner Zemlich.
Thank you, Chair Thompson. I went back and looked at the language around wastewater, domestic wastewater treatment. And for that, the department has considered a feasibility study. So is it necessary to have the permit now because we don't have standards? And as you mentioned, Chair Thompson, there's a lot of other features of a permit that we wouldn't have just yet with having the NOI for this 5-year sunset period. I just don't see how you issue a permit without standards. And if you can do it if you can have a feasibility study for wastewater project, why do you, other than the Produce Water Act, and is there a provision in the Produce Water Act that says it needs to be done right now?
Commissioner Brankard.
Thank you. I think Commissioner Laney has kind of nailed this in some ways here, because the concept of the NOI comes out of current discharge permit rules. And it's basically, you submit a project to the Environment Department. If the Environment Department determines it doesn't require a discharge permit, have fun, right? That's the end of the Environment Department's jurisdiction over that project, okay? This has never quite been like that, and it's moved even further away from that over time, because this thing requires all sorts of plans and all sorts of statements. It's starting to look more and more like a permit already. I mean, it's you've got to submit how you're going to get rid of this stuff. You're going to submit how you're going to handle it. How you're going to store it. All this stuff, all the things you would put in a permit that would become permit conditions. Okay, so it's really not anywhere near a notice of intent that already exists in the rules. It's a different creature already. Okay, and so I think the issue that at least one of the issues that the parties have raised is, okay, if it's going to be a permit, it's got to go through the permitting process. Okay, public notice, opportunity to comment, opportunity for a public hearing, all of which is set forth in the groundwater rules that we have, 20.6.2. And so the question is, can we just simply reference those process and then ultimately just sort of call this a permit, that the department will issue a permit, which includes all these, it adopts all these plans that you've submitted and you're required to comply with them. And if you don't comply with them, well, you violated a permit condition. Therefore, you're subject to enforcement. you don't store it correctly, if you don't dispose of it correctly, all that is a permit condition and therefore subject to enforcement. You raised that issue at the last meeting I saw about how is this enforced? How do you enforce under a notice of intent? Well, it really needs to be sort of a permit. So it's permit conditions that you can enforce.
I agree with this, what you just said too, and we actually went the step further to add additional reporting requirements the last time that we met, to include monthly reporting, and that the department shall publish on their website all of the procedures, the plans, the data, the information, and that the notice of intent applicant, I don't know if that's the correct phrase, that they would have to notify their immediate neighbors, if you will, of what they were going to be doing. I believe we included that. I may have misspoke on that one, but certainly we included the monthly reporting and the publishing, because I'm looking at it as a redlined item that we added. So it talks like a permit, but it doesn't say that it's a permit.
If I might just add here, the Center for Biological Diversity, Wildlife Guardians, and the frontline community members and NEE had, and this is on page 39 and following of attachment A to my original report, they proposed just a completely new C, which they said, as established by the Produced Water Act, a permit is required. And they don't just throw it to 20.6.2. That's my point. They don't just say pilot projects need to go through the DP process in 20.6.2. What they did then further along, though, was at the very, very end, offer up a whole new D&E with lots of reporting requirements. And again, they're calling it a permit, not necessarily a discharge permit. And they certainly don't refer to 20.6.2. So what they're describing is a permit without being a discharge permit. If you wanted an example of something that was a permit without being a DP.
Okay, where does that leave us? Mr. Brankert, are you suggesting we craft a permit requirement, or no, a permit process, presumably with conditions today out of section 400C?
Mr. Chair, I don't know what I'm suggesting, really.
I don't either.
Frankly, I could be just as happy with eliminating 400B and 400C. So, I mean, that's the other option. Just completely eliminate the pilot projects and have the Environment Department go back to the drawing board on this.
Commissioner Laney?
I'm going to skip that thought for a second because I need to digest that a little bit. But Commissioner Zimlick had talked about there's another program where they do, I don't know, do they call it a notice of intent? Yeah, could you talk through that just a little bit more? I just was inclined to hear that just to kind of have a full picture.
It's called a feasibility study for wastewater treatment technology. So I'm trying to find.
It's section 201. in the red line markup. It begins near the bottom of page 8.
Thank you. So 20.6.8.201 feasibility studies. This is under domestic wastewater reuse, direct and indirect potable applications. But that refers back to permitting 20.6.2, so it doesn't really get us anywhere. I know I did too.
You know, I hate to throw out another wrinkle because I think, well, actually, I think it's sort of important. And that is when we start talking about direct or indirect potable, we're not talking about regulations under the Water Quality Act. We're talking about what regulations under the Drinking Water Act. And that is subject to rules promulgated by the EIB, not by us. So this is sort of a, to my way of thinking, this is something that needs to be addressed in another venue, not today.
You're right. I was just looking to see if we could draw a correlation between this and what we're facing with produced water, but you are right.
Where do we stand? Mr. Zimlick, your light is on.
In terms of the language of the NOIs as compared to permits and referring back to current process. So the department asked us to consider a number of things, but one of the motivations behind this rule was, not evaluating discharge permits without standards and without a lot of the data gaps being filled in terms of produced water to their satisfaction. And then there's the existing projects that have been conducted under NOIs. And aside from some of the small additions that we've made here regarding notice, I'm not sure that I'm satisfied with the ability to enforce the NOIs that have not been conducted as they were intended to, which we've already seen with the existing ones. And so that is a concern of mine as well.
Yes, I agree. One of the issues, this was brought up during the hearing, was an NOI doesn't have an enforcement provision. So if a project that was submitted in NOI and was not performing in compliance with the applicable laws, whether they be surface water or groundwater, the only option for the environment department would be to take an enforcement action. Whereas if they had a permit, conceivably, it would be more expedient. They could deny the permit. They could implement fines or other conditions. I guess where I'm leaning is sort of, Commissioner Brankard said perhaps we ought to just throw the whole thing out. And I don't feel, as I said earlier, I don't feel that we can create a permit process out of what has been provided in testimony or what has been proposed by the Environment Department.
I have a question. This may be an unanswerable question, but are there examples of other programs within the Environment Department, water related, that they have used this type of process where they have an NOI and they collect data so that they can then create those standards, if you will? Have they done anything similar to this in the past? I'm not familiar enough with their interworkings to know. I'm not sure that this is a question the commission can answer or not, but I am curious if.
Commissioner Laney, even if it were true, and I'm not aware that it is, that evidence is not in the record.
It's a good point. Yeah, I appreciate that. I feel like there's a gap between what we have here and what they can take and have regulation and kind of do compliance on without it being a full-fledged enforcement action, which they'll have to have an investigation and for cause reason, and it's very time consuming, like you've suggested. I don't know that I have a solution to offer up here. The wheels are turning, but they're not turning anything out just yet.
We've heard from several commissioners repeatedly. I wonder if there's others, Commissioner Bayless or Commissioner Vigil, if you have any thoughts on this. I don't want to have just this conversation dominated by 4 or 5 of us. Commissioner Bayless.
Commissioner Bayless. I'm sort of getting higher in altitude and looking down at things, and if the Produced Water Act is requiring a reuse permit, that's not a discharge permit. You can have all kinds of reuses that don't involve discharges. And I'm not sure that trying to fit what the Produced Water Act wants versus what NMED has to offer in terms of an existing protocol is the best fit. And I had another thought, but I can't remember it.
Commissioner Barunda, we haven't heard from you in a while. Have you? It's a little hard for you to communicate with us because you're 300 miles away.
No, actually, I've been listening in, and I've been kind of racking my brain as far as experience with, discharge permits, and in this case, it's reuse water. It definitely is a gray area, sir. But I just don't think that we really have any way around it, other than basically considering this as some sort of permit. I say that because even when a new well is being drilled, that requires some permits, and water has to be tested to make sure there's nothing, of course, a major contaminant or anything like that. So that's just drilling a well. So in this case, the water is actually being produced, yes, and even though it may be on a closed system, I completely see that point. But at the same time, I think it's going to have to fall under a permit.
Thank you.
Thank you.
Mr. Bayless.
And yeah, Commissioner Bayless, the other elephant that's in the room is PFAS. And I think that PFAS is the bugaboo in fracking waste or fracking water. And there's not we have no established standards for it, so it's difficult to deal with the how much treatment is needed if you don't have a standard. And I think that's the other thing that underlies all of this. It's the emotional part of produced water, and we don't know enough about it to really be making wise decisions. And it's sort of, to me, it's sort of underlying all of this is that question.
Thank you. Commissioner Vehil?
Looking at this, I'm wondering, we've got the basis for what we want to accomplish. And, at this point, I think, we need to just go ahead and decide one way or another, if we want to accept these red lines that we talked about last month, and, give it back to them, the department. That way they have something to go by. There's nothing to say that the parties can't come back after these have been posted. They can always come back and make changes to it. This is the first attempt at it. I mean, like I said, when we did the dairy rules, we did the copper rules. I mean, we put something out there, and then they came back to us numerous times. And like I said, this is the first time out. I say we put it out there. If you're not comfortable with something that's out there, then propose a change to it at this point. If you don't, like I said, it can always come back.
So where do we stand? Commissioner Brankert, are you prepared to make a motion?
Well, I guess I'm wondering whether the commissioners feel like we ought to give it a try to revise this rule or not. I guess I could make a motion to find out.
Commissioner Zemlich.
Thank you. Chair Thompson, I have a question from my non-regulatory legal background. Is it possible to create a permit? This is obviously a bare bones permit for the pilot project itself, rather than another kind of discharge reuse permit, so that there's something in place to sort of guide what I think the intent was, and also potentially add enforceability to it.
Mr. Chair, while I've been sitting here, I have kind of gone through the rule, and I actually don't think it would take that many changes to do this. Okay, I think if you start by looking at 400C, where it says reduce water notice of intent, scratch that out and say pilot project permit. Okay, and so and then on we eliminate where it says notice, you write applications, and go through there. And so there's just a few little changes, in that first section C1, you would say that somebody would submit a pilot project permit application. Okay, and then 1A, instead of notices, application. And then just keep going from there. I think the biggest change, though, would be over when we get down to the changes we made to C1A 12, which is the public notice. Okay. The question is, I mean, I would suggest that that paragraph be deleted and replaced with the application shall comply with the public notice, again, hearing requirements in 20.6.2, and then we can give the sections 3108, 3109, 3110. There's like 4 or 5 sections. And then they would have to do the formal public notice, you know, what it says discharge permit. They're just following the requirements in there. So they would do the public notice. There would be an opportunity for public comment, opportunity for a public hearing. You don't like it, appeal it to us. Then it goes on from there to the courts, you know, and all that is in the rule there. And so steps are all there. So I think we've made so many changes, and the department has made a number of changes through the process, that this thing really does, you change the name, it suddenly is a permit. I mean, it basically is a permit already. So we're not making that big a difference, I think, in what we're doing. It's mostly nomenclature at this point and process.
Chair Thompson. So having no experience with permits and the permitting process, writing a rule with the permitting process, would there not need to be a section about enforcement? And is anyone on this commission having experience to be able to write that section? If the answer is yes, we need it.
Mr. Chairman, the Water Quality Act makes it clear that a violation of a permit leads to an enforcement action or potential enforcement action, either a compliance order or a court action. So that's all set out. I mean, it's a violation of a permit or it's a violation of a section of the rules. Either way, that's the basis for an enforcement action. But we don't have to do anything as long as it's part of the rules. You know, the enforcement of the rules is in the statute.
So a follow-up, does it also include what that enforcement action is?
You mean hanging up by their thumbs, or what do you mean? Yes, there's penalty amounts, the specific penalty amounts per violation per day.
Also, the permit can be revoked, and also your bad conduct under one discharge permit can be used as a basis to deny future discharge permits.
So going back to my original question, or is the answer to my original question, then we would not need to add a clause in there about repercussions of not.
I don't think so. And so in our goal of achieving this harmonious whole here, what struck me when I went back through it is there's a second provision in the Produced Water Act, and of course I can't find it now, that says that basically the commission will implement produced water regulation under the Water Quality Act. So the Water Quality Act, then I think it's easy to have it be the framework for any of this.
Let me respectfully disagree with you, Commissioner Brancard. I agree completely that the items listed in 400C produced water notice of intent are, that's a very good and comprehensive list of what should go in an application. But I think what needs to go in a permit are things like duration of the permit, monitoring and reporting, performance standards, uses of the treated water, penalties and enforcement, and an appeal process. Some of that I'm sure is in the Water Quality Act. I'm not sure. But again, I don't know that we've got any testimony on which to establish some of those factors: duration, monitoring, reporting, performance standards. What would be the allowable uses?
Well, I guess, Mr. Chairman, I'm still stuck in this pilot project mode. Okay. That's the only thing we're authorizing under a permit. No other uses. Only this project to test something in a way that doesn't involve a discharge of produced water or treated produced water. Okay. It's a pretty narrow area that we're allowing permits for. So I guess I'm a little less concerned about standards and whatever, because the point of the projects is to help develop the standards.
Commissioner Chair,
Please.
I'm on board with what you just said. So you suggested that it be a pilot project permit, which includes all the words that we need to. I quipped that it talks like a permit in this language here, and I'm in agreement. I think that we could add to this, and we could have a pilot project permit that's going to look different than a permit elsewhere, because this one is for pilot projects. So the words are important here, and I agree with what you just said. We can use that lens in this case. I don't want to leave here today and our answer be that we send it back to NMED. I believe that in the testimony, the gap is that they need this research to occur. NMED agreed, oil and gas agreed that this research is essential. They may not agree on whether or not it can be discharged or otherwise, but the information from this pilot projects is important for us to take the next step forward. And I think we have to try and do our due diligence to move that forward without conflicting with what was part of the testimony and the technical evidence. I think we could draft that. I agree. I think we should try to draft that. I don't know if that needs to be codified in a motion. Again, novice, but if we could start lining out some language for us to debate, I think it's worth trying. And if it's not successful, at least we put the effort into seeing that we could get there.
This is Commissioner Zemlich, and I agree with Commissioner Laney. The objective of this rulemaking in part is not to figure out how pilot projects are gonna function forever and ever. It's how to get to a place where you could potentially consider the reuse of this water. And so I think I agree that if we, to what extent that we can include language to permit the projects, pilot projects. And I think, and I'm sorry to continue, but in my limited experience, and it's not in writing conditions of approval, but in reading conditions of approval, is they would look very different depending on the type of pilot project and what's being proposed. And I feel like the public notice is a robust way to inform the public of, you know, size, application, all of those things that would be part of that facility's permit.
So I guess my question would be, how can I help? That is to say, are all the commissioners who are voting committed to coming back tomorrow? It is almost 4:30. We could be in the room another half hour or so, but I can't draft and listen, but I could tackle something if I could go home and email it to you guys later tonight, and you guys could come back tomorrow, and you'd at least have something to look at. And it would be based on existing proposals and evidence in the record and arguments already made by the party. None of it would be creative work.
Chair Thompson. So Madam Hearing Officer, if I understand you correctly, you're volunteering to do the first draft.
I am.
I like that.
That's fine, except we've got to give her some parameters to work from.
I feel like I have hung on every one of Commissioner Brankert's words, Commissioner Zemlich, Commissioner Fry, Commissioner Laney. I feel like I have it right here.
Mr. Chair, do you want me to start wordsmithing?
Before you do that, I noticed that you didn't accept my concerns. You mentioned the other commissioners. And again, I think the permit ought to have some of these other criteria in there. Duration, monitoring, allowable uses of the treated water, penalties enforcement.
Yes. And actually, I'd already heard the discussion around enforcement and penalties. And some of what you're describing is already really in what they're describing as being required as part of the notice of intent. And some of the rest of it actually was in NEE's proposed language.
Okay.
For their permit.
Mr. Brankart.
Okay. So let's start with 400B. 400B4. Pilot projects shall not commence until the department has issued, we've already deleted the discharge permit, right? And just instead of discharge permit, say issued a pilot project permit and delete the rest of the sentence. Okay, then we go to C. The title of that should be pilot project permit. C1, the sentence shall, at the first sentence there, shall submit to the Groundwater Quality Bureau of the department a pilot project permit application prior to use. C1A, replace notices with application. Now, I think that the tricky part will be, as I said, this C112, which I would propose that there be a requirement, and I don't know that it needs to be in this place or somewhere else, that the permit application must comply with all the public notice set of requirements. And I think it's 20.C.2.3108 to 3113, although there's one section in the middle there that doesn't apply. Transfers. So C1C, the first line, based on the information provided in the place notice of intent with application. And then C2C, the department shall publish on its website all applications for pilot project permits. And I don't know how the department handles all their discharge permits, but I know I think this is true of some of them, and it's certainly true. My experience, say, in the mining sector, where you get an application that's full of plans, that rather than putting those plans in a permit document, the permit document just says you shall comply with, the storage plan in your application. So they don't, permit document itself doesn't need to be quite detailed. It's the application in the sense that provides the requirements because that's what the applicant says they're going to do. If the agency doesn't like it, they make them go change their application.
Solid waste permits, the same.
Yeah.
Chairman, this is Commissioner Barunda. Yeah, that's a good statement. I agree. That's typically how it's done for water and wastewater. So, yep, agreed.
But I do agree with the chair that perhaps that we add a 5-year duration. That's what a discharge permit is. So
I have a question, I guess, maybe confusion, actually. That's probably a better way to quantify what I have. If the rule is sunsetting in 2030 and the language is changing, wouldn't that sufficiently sunset any of the pilot projects if those then are changed to discharge permits, whatever the future, I'm not sure what the future holds, but haven't we already set a date essentially by that?
Not necessarily, because the discharge permit process actually includes some language, and I can't point to it right now, that basically a discharge permit kind of continues in force and effect until.
Thank you. I needed that clarification. Obviously, I was confused.
With NPDES permits, I think it's referred to as a continuance.
Chair Thompson. Commissioner Fry, just to be very clear, I think we need to be as specific as possible so there's no room for misunderstanding.
of course, if we decide that our changes have made the rule perfect, then we can make the duration permanent.
We can decide that in 5 years, right?
So I've just been going through the 20.6.2, the permit application and criteria. And perhaps we don't need everything that's in there, but they do have appeals process. They have reporting. And so forth. I don't know. Do you want to include that kind of specificity in this?
Mr. Chair, what I referred to was the notice and comment proceedings that are in there. I avoided the sections that are what you're supposed to put in a discharge permit application because we've already defined what's in this application. Okay. We don't want to confuse it with the discharge. All we need is the process for notice, comment, hearings.
Okay. I'm comfortable with that. Comments? So let me just briefly summarize. As I understand, Commissioner Brancard is suggesting modifications to section 400 point, primarily to 400 point C, that will apply to discharge permits for pilot projects only.
Discharge permit.
I'm sorry. Pilot project permits to conduct a pilot study. Thank you. Do you want to put that in the form of a motion?
Well, I think the idea was that hearing officer would try to scribble this on a piece of paper and then we can look at it tomorrow and go, this is dumb, throw it out. Yeah. Sure, it's fine. Okay. I'm seeing heads nod. So we'll reconsider that tomorrow. Is there anything else we want to tackle today? Commissioner Laney.
I'm assuming that after we see this tomorrow, we will circle back to some of the other issues that were brought up today. Like the volume of water, perhaps related to a pilot project, things like that that were mentioned. Yeah, that's tomorrow's agenda. Beautiful. That was my only question.
This is Commissioner Fry. I was gonna suggest maybe we start on the line by line so we don't have to deal with that tomorrow. So we have a little bit of time.
I think that's a good idea. We do have a little bit of time. The one thing where there was a lot of changes made were the definitions. So perhaps now might be a good time to do that. We agree? Okay, so I'm looking at page 1 of the red line markup. It's 20.6.8.7 definitions. And with your agreement, I just say we go through them. Okay, so first one.
Actually,
can we have a pee break? Can we have a pee break? This is the court reporter. We've been going 2.5 hours.
It has been long.
10 minutes. Why don't we just break for the day? If a 10-minute break is going to put us awfully close to 5. Yeah, let's just.
Perfect.
We need a motion to adjourn? No. Okay, we'll reconvene tomorrow at 7:30. No, tomorrow morning at 9 again. Okay. And again, thank you for all your patience, everybody online, everybody in person. We've made progress. I'll see you at 9 tomorrow.